appeal in the matter of Mead Realisations Ltd. And housing and coming from another.
Thank you. It feels very warm in here.
Yes.
Last week it was very chill. Can we do anything, Associate? I'm just wondering if we can. It just seems too hot, really. Turn it down, yeah. Is that going to work? Yeah. We'll see how we go. Does that control it for the whole court? Well, we'll see how it goes. I'm also slightly elevated here. That's better. Slightly better. Yeah. Lord Banner.
Good morning, my lord. May it please the court, my lady. I appear with Mrs. Isabella Bueno for the appellant, Mead. My learned friend, Mr. Flanagan, appears for the Secretary of State. Can I start by thanking the court for sitting early?
Well, not at all. It's caused inconvenience to no one. I hope it helps you, the latter part of the day, but we'll have to see. You know, we'll go at the pace that is right, and if it has made a difference for you, then we're pleased.
Thank you. Que sera, sera, but I appreciate it, and it wasn't in any way taken for granted. I hope.
No, of course not. No.
Thank you.
All right. Well, thank you. Yes.
My lord, can I start with housekeeping?
Yes.
You should have three folders: core bundle, supplemental, and authorities.
Yes.
And there are two further documents that, with Mr. Flanagan's agreement, you should have before you. I'll tell you what they are. One of them is relevant extracts from what's known as the Taylor Review. That's referred to by the judge and was before him at paragraph 63 of the judgment. It was the review that led to the establishment of the PPG. I'm going to take you to that shortly.
Right.
And the other is the pre-NPPF national policy in relation to the sequential test. My Lord Sir Keith Lindblom will probably recall that.
I do.
The PPSs, which were consolidated into the NPPF.
I do remember.
The key point is it's materially the same for present purposes, reasonably available, so there was no change.
Okay. And that's March 2010, I see.
Correct, yes. So, and then the NPPF was consulted upon in the summer of the following year, and then issued 2 years after.
Okay, that's really helpful. Shall we put those in?
Where you please, I mean, sort of. What can I have a toss as to whether policy goes into an authorities bundle or a main bundle, wherever you prefer.
Well, I think let's put them in right at the front of the authorities bundle, and then we know they're there. Okay, thank you.
Thank you. So, if it's convenient to report, the way I propose to structure my submissions is as follows. I'm going to start by taking you to the key policy provisions. And within that, I'll show you the Taylor Review too, to put the PPG into context.
Yes.
I'll then, second stage is I'll take you to the relevant parts of the inspector's decision, and I'll make some submissions on the proper characterisation of his analysis as to the effect of PPG 728.
Right.
There seems to be a difference between my learned friend and me, and indeed the judge below and me, as to how the inspector's decision is approached and characterised, and that's really part of Ground 2. Is Ground 2.
Right.
Then, thirdly, I will take the court through the previous case law on the status of the PPG, recognising, of course, that none of it binds you, but you may find it instructive.
Yeah.
And I'll make some submissions on the principles to be drawn from them. That's the third point.
Yeah.
Fourthly, I will then explain where we say the inspector went wrong. And fifthly, to the extent not already covered, and it may well have been covered by then, where we say the judge went wrong, and within that context, why the grounds aren't academic as suggested by my learned friend. So I hope that gives you the broad route map of where I propose to go. So if I may, I'll start then with section 1 under key policy provisions.
Yeah.
Excuse me. And could I ask you to turn up the supplemental bundle for that? And within that page 24, which is a within the NPPF, and that's the key is it, the pagination, the bottom right-hand corner, 24, behind tab 3 if you have tabs.
Yes, we do.
Paragraph 162, the text will probably be familiar from the skeletons and the judgment anyway, but the key sentence is the second one. Development should not be allocated or permitted if there are reasonably assailable sites appropriate for the proposed development in areas with a lower risk of flooding. And that's the paragraph in relation to which the PPG corresponds or refers to. I'll come on to what the cost. So that's all I wanted to show you in relation to that. Can I then ask you to go...
I'm just pausing while,
Yes.
while we're at it. There isn't a definition of reasonably available sites in the NPPF,
Correct.
is there? I say no definition. One would expect, if there were to be a definition, I'm not saying one would expect there to be, but if there were to be, one would expect to find it in the glossary.
Correct.
But it's not either in the glossary or elsewhere in the NPPF.
And in essence, that's a point which I will develop later on, in essence, what I say the inspector has done, and the judge wrongly held was acceptable, is the inspector has treated the PPG as essentially inserting via the PPG a definition akin to an entry in that glossary, which I say the PPG can't do if it's to be treated as a rigid definition.
Yes. All right, fine, thank you.
A sort of higher level point for those members of the court that are less familiar with planning is the sense of the framework being, as you'll see from this part of the supplementary bundle, a single consolidated document that's issued as a single document. It's consulted upon. There's currently a consultation ongoing, started in July. In case it helps, I did note the court brought forward the date in light of that. The current anticipation is that the framework will be published just before Christmas. A lot of people think it will be the 19th of December. That's a guess, but it's an informed guess.
Right.
In case that is of any use to know in terms of how you approach the time of your judgment.
Do we know whether what is the nature of that consultation?
So it's a formal public consultation. If you'd like, we can provide the consultation documents. They established a practice that's been done for all the iterations since the original one. There's a track changes version.
Yeah. Is it a statutory consultation?
No.
Right. So it's simply the government doing that.
Yes. There are different views on whether there's a legitimate expectation by convention or consultation. We don't need to go there.
Right. No, I don't think we do need to go there. But is it a general consultation on the whole NPPF with a focus on particular passages, or is it just on particular passages? How does it work?
So how it works is there's a draft text with track changes.
Yeah.
The consultation, certainly as I understand it, is on the proposed changes rather than on the bits that are not proposed to change. I'll have to double check because there may be a catch-all question at the end. Are there any comments?
That's what I was wondering.
I don't know the answer to that question.
No, well, that's fine. We perhaps
let
you come back to us on that. But just sorry to persist on this for a second. Is there a specific consultation or track change consultation on this passage or its successor passage?
No, it's unchanged.
So para 162 as was, now 168, I think.
And it'll be renumbered again because every single time they change the numbers.
Of course. That's not a specific consultation subject. Right.
And then there's a consultation paper. So there's the draft text with track changes. There's a consultation paper which provides an explanation of the proposed changes with specific questions. I think there's a catch-all question, but I don't know. I can check. Right. And then there's a timescale. And then a response to the consultation with the final version published.
I just feel, I haven't spoken to my colleagues about this, that it may help us to have an agreed short note on this.
Sure, we can.
Not obviously during the hearing itself, but perhaps in short order after the hearing.
And if you'd like a flavour, we can provide the document just so you can get a flavour.
Yeah, no, that would actually, I think that probably would help us.
It's all online, so I'm sure Mr. Fanley can do
that.
that.
Would, if you could make that a task for you both, that would really.
I can
all three of you, I
do
should
that
say.
by 9 a.m. tomorrow if that works for Mr.
Well,
Flanagan.
that's pretty tight.
Or
I think
whatever.
we can say by noon tomorrow.
Yes.
It gives you enough time. I think.
Thank you. Saves a bit of sleep.
You've got other things in the meantime.
Thank you. So that's the framework, and you'll apprehend that obviously I contrast that with the PPG, and I'll come on to explain why. Then could I ask you to go in the same bundle to page 8, which is behind tab 1. Excuse me. And this is the policy CS3, the development plan policy that again you'll see mentioned in the skeletons and the decision and judgment. Mr. Flanagan makes a very fair point that you shouldn't be misled by the date at the top that says January 2017, because this policy was adopted some years prior. It was 2013, wasn't it, originally? April 2012, forgive me, 2012. But what happened was other parts of that core strategy were then quashed by the court. There had to be a review, I think, and so hence the core strategy has the title 2017, but this policy is derived from 2012.
Okay.
Nothing turns on that, but just FYI.
No, but thank you for that. Yes.
Then I draw attention to the second paragraph, where it says development in flood zones 2 and 3 will be permitted where it's demonstrated it complies with the sequential test set out in the framework, unless those 2 bullets. And that's what the inspector and the judge called the first part. Actually, that's the second paragraph of the first part.
Well, it says and associated technical guidance.
And that's dealt with in the that's been abolished. The judgment and the inspector both considered that passage was OTOs. It's not a reference to PPG and has not been treated as that.
All right, so what we're looking at here actually is a draft, is it?
Yes, so the chronology is that as of the... when this was adopted, the MPPF had been issued a month prior. But when this policy was examined by the inspector in the local plan process, the MPPF was in, the original MPPF was in consultation draft. So the examination of this policy would have been against national policy prevailing at that time, which would have been the PPS.
Right, so to get the policy as it was, in the form it was in at the time of the inspector's decision here, do we need to make excisions to this?
No, the reason why you don't, my lord, is because it was accepted by the inspector and by the judge below that national policy hasn't materially changed at any stage.
No, national policy hasn't, but
I'm sorry.
But the development plan policy.
No, it's exactly the same. So this policy, though it has the title 2017, because it's the plan itself was updated, this policy was in precisely the same text when it was originally adopted in 2012.
But with or without the words, I know that they're OTOs in the sense that, well, they're not relevant to our discussion here, but with or without the words and associated technical guidance. So
the associated technical guidance was the technical guidance prevailing in 2012, which was done away with.
So, I'm sorry to interrupt you, but the policy that is printed on the page 8 of our bundle,
yes,
is the policy in its form at the time of the inspector's decision?
Correct.
Right. Fine.
At all material times, that's been the policy.
All right. Sorry, I interrupted you.
No, so you can, and I'm not seeking in any way to bat it away unduly, you can ignore the words associated technical guidance. It's not the PPG, wasn't treated as such by the inspector or the judge below. I don't have the paragraph reference at the time.
Fine, that's understood.
Decision. So the key point I want to draw attention to is that second paragraph complies with sequential test in the MPPF. Then those words are qualified by the next paragraph, which says for the purposes of the sequential test, and then sets out various provisions.
Yeah.
And those include, at 2, a site is considered to be reasonably available if all of the criteria set out there are met.
Yeah.
I won't read it out because I expect you're sufficiently familiar with it. And to be clear, that the fact that this policy wasn't examined for soundness against the MPPF doesn't matter, because PPS 25 also had that term reasonably available unvarnished. And clearly the emerging NPPF was plainly in contemplation when this policy was being examined because it's referred to.
Yeah.
And my learned friend Skeleton at paragraph 7, consistently with the inspector and the judge, accepts that there's been no material change in the policy wording or framework on the sequential test since the time that this policy was adopted. So the only thing that's said materially to have brought about a change is the PPG.
Yeah.
Then, when my lord's finished writing your note, page 29 of the same bundle is the next stop. Within tab 4, B4. And this is the PPG.
Yeah.
And the passage at the centre of the debate below, and indeed today.
Yep. What is a reasonably available
Correct.
site?
We refer to that as paragraph 7028. They actually have reference IDs in the numerical format. This is the same with all the PPGs. There's a section of the PPG, a paragraph number which is 28, and then what follows is the date in which it went online.
So for us to use the shorthand of paragraph 0-728 is correct, isn't
Yes, 7-028 is the convention in the planning sector. Technically, one also then puts the date, but no one does that in practice. So everyone uses 7-028.
So if we, in our judgment, refer to paragraph O hyphen dash doesn't matter, 728.
Everybody will know what
Everyone will
yes, correct.
not think that we're referring to the wrong thing. As there are a number of sections, it's quite important in a sense because there are quite a large number of sections in the PPG with these very long numbers.
Yes, there are, and we can't. We could technically provide you with the whole PPG, but it'd be twofold as worth. That's the last thing you'd want, and you would definitely not thank me for it.
Well, it's not even the last thing we'd want. It's something we wouldn't.
Absolutely wouldn't want, even if it were the last thing. No, quite.
You really wanted to go to sleep.
No, quite. Well, you would do pretty quickly. But actually, that rather demonstrates a point when I come on to when no one understands the different character of the PPG and how it's held out, or how it's packaged, which I say is relevant to its Tesco v Dundee interpretation of what it's actually doing in law. I'll come on to that in a moment.
Right.
The passage in particular that the inspector saw as defining, in his words, I would say redefining, reasonably available, essentially, as I say, putting this definition into the glossary of the framework with the effect of how he treated it, were in particular reference to a series of smaller sites, because CS3 said the candidate had to be one site that did the job. You might have picked up there was one site that was 74 rather than 75, and under the development plan that didn't count, even though it was a near miss. But you could aggregate under so the PPG said, and didn't need to be owned by the applicant. Next, can I ask you to take up the Taylor review? Because as I'm on the PPG, this is probably as good a time as any to provide a little bit more colour on what is the PPG. At this stage, trying to be neutral, because I'll make some submissions on what then I say the legal effect is, but what is it actually said to be doing? So this is the Taylor review.
All right,
These are extracts. Don't apprehend Mr. Franklin says they're unfairly selective extracts. To help you, I've highlighted, and I hope you have the highlight, some of the more illuminating passages of the Taylor review. Could I just ask the court to spend just maybe 30 seconds, just sort of, however long you'd like, just scanning the highlighted text to get the flavour of how I say this, the PPG was set out as supporting the framework as opposed to being a rival corpus of policy.
So what are we looking at
Just
now?
if one looks at page 3, 6, 7 and 8, there are some highlighted passages, and don't ask you to spend a huge amount of time on it, just to get a flavour of how it was held out at the time.
Right.
So on 3, its aims, government planning practice guidance, which supports the implementation of national policy, which I say is at a piece with my characterisation of the job it's doing, and indeed that of Mr Justice Dove, etc. in the cases.
But this, this is a report, or a review report, by Lord Taylor.
Which led to, which was accepted, the advice in this report was accepted, which resulted in the...
But what is its legal status, actually?
The report, well, its legal status is...
how does it assist us to understand what the PPG
correct.
is doing?
It's made to understanding what the intention of the PPG was and how it's held out by government, which I say is of relevance to construing it in the Tesco Dundee sense. What is actually the PPG?
So it's relevant to construction?
Yes. Because at the heart of Mr Justice Holgate's judgment, he said, well, the PPG, the source of power for issuing that, is the same as the source of power for issuing the framework, so therefore the PPG can contain a rival corpus of policy. I say that's to ask the wrong question. It's not so much the source of power, but what objectively, in the Tesco Dundee sense, is the PPG's function and role.
And you stress the references to support and
correct,
supporting.
my lord, exactly. And all the highlighted passages, I say, are at a piece with that. I mean, the first one, perhaps, is the most pithy statement.
Yeah, all right.
There was previously, as my lord Sir Keith Limbaum will be aware, when the PPSs were in force, there was a whole range of guidance in different formats, government circulars, etc. Part of the intention of the PPG was to put it all together.
Yeah.
And you'll see that. I don't dwell on that, but I do ask the court when reflecting just to consider the other highlighted passages, obviously reading in context, all at a piece with that supports policy rather than defines, rewrites, is a rival corpus, etc.
Yeah, all right. Thank you.
And as you'll be aware from the references in the arguments in the judgment to Mrs Justice Leaven's judgment in Solar Retail, the PPG isn't consulted upon. It's not you can't download it, as I said, in any particular consolidated format. It's changed. I mean, it could be changing now as we speak, without any foreshadowing, etc. Now,
yeah, but the NPPF doesn't have to be consulted.
Correct. And I don't. Again, that's not a point in terms of the legal power, but what it is, it's illustrative and consistent with my characterisation of the proper objective interpretation in the Tesco Dundee sense of the PPG as doing something different to the framework. It might come from the same source of power, but it's there to sit beneath and support rather than to contain a rival corpus of policy. And so it's a Tesco Dundee interpretation point, and that's relevant in that sense, because that's how the industry understands it. That's how it's held out to the development sector.
Well, the industry understands it as supporting.
Correct.
All right.
I mean, one doesn't want to be overly glib, obviously, or indeed glib in any way, but the clue's in the name. There's a national planning policy framework and a planning practice guidance. All of that's consistent with my characterisation objectively of the respective roles of the two things.
All sorts of verbs are floating around here, but can supporting encapsulate amplifying, elucidating?
Well, that depends what elucidating. I spent a lot of time looking at dictionaries in the last couple of days,
Well,
as it happens.
Yeah, I've been looking at words like elucidate.
Yes, so I shed light on.
Light on, yes.
Guidance, but not redefining, not rewriting. And I'll come on to that when I develop my submissions.
Right. So
But
not
elucidate, essentially, in my submission, this
not
concept is
rewriting.
provide guidance on.
Yeah, I think one has to be careful with the language, particularly when we get into the territory of changing or
Yes.
altering or amending,
Yes.
because there are different ways of doing that. I mean, one way of doing it is to add things to explain, and the other is to contradict.
Can I was going to deal with this later, but can I, on that point, just while we're on it, my lord, meet that point by reference to Mr. Justice Holgate's example of heritage policy. It's in the judgment, and he cites the BPG.
Yeah.
Just bear with me. 64 and 65. I think it's particularly 65 of the judgment. Page 73 of the call bundle. Mr. Justice Holgate saw this passage as doing the same as how the inspector characterised 7028. I say not so, but let me just take you through. This is the PPG dealing with the concept of substantial harm to a heritage asset, which is not defined in the framework. And note the way it's put in general terms. Substantial harm is the high test, so it may not arise in many cases. For example, you can see obviously what I'm emphasising here. ... An important consideration would be ... Now that, in my submission, is paradigm elucidation, in the sense that I understand that word to mean, sort of guidance. It's not in any way constraining. It's not saying this is the only way of achieving compliance or meeting this particular part of the framework. It's giving a steer on where the focus should be. Whereas how the inspector, and I am slightly jumping ahead, but how I characterise, this is where the proper characterisation of how the inspector treated the PPG is important. The inspector did something different. He saw 728 as defining rigidly what reasonably available meant. Not setting out a focus, things to bear in mind, things to bear particular in mind, but things which had to be done. Otherwise, you couldn't meet the term. That is different. That's what I might mean by rewriting, redefining, in contrast to the elucidation, proper, done in that passage. I hope that may shed some light. I don't know, that's a rather unfortunate term. Elucidate.
That's elucidating
my
your
approach.
submissions about elucidating. Yeah. But just a question on this. If you have a situation, I'm not saying it's this case, but if you have a situation in which the NPPF expresses a concept which is not defined in the glossary or anywhere else, or explained in the body of the NPPF itself, is it a legitimate role of the PPG to provide that explanation for its own part, which is read together with the NPPF when you're applying it?
Not if the PPG is then taken to be the only way that the NPPF approach, the NPPF terminology can be satisfied. So let me put it again, I'm slightly jumping ahead of myself, but you'll pick up the skeletons. Pre-7028, reasonably available was a broad, open textured term, capable, I say, of a fairly wide range of reasonable local applications, of which CS3 was one. It was within that wide range.
Right.
What, on the inspectors and the judges' analysis, 7028 has done is to narrow that wide range so that CS3, which previously was within the range of reasonable applications, now fell outside it. That, I say, the PPG can't do, either in this context or in the context my Lord has asked about.
Well, perhaps I shouldn't be tempted to pursue that, tempting as it is.
It may be that we might come back to it.
Well, the thought that's in my mind about this is that you've got. Let's make it about this.
Yes.
This case, if you like. You've got the NPPF referring to reasonably available sites, and then along comes the core strategy, and has its own definition. Now, that definition could be a very narrow one. It could, I mean, it could, on your submission, it could legitimately be a very narrow one. And then along comes PPG and says, no, it's actually a much broader, wider thing. Can it do that?
Well, provided that the local plan definition is within the range of reasonable applications of the framework text, the PPG couldn't then effectively render the local plan out of date out of kilter with the framework.
It's a
That would be
it's
to move the
ultimately a
goalposts.
question of weight. We know, going back to basics, if you like. The NPPF and the PPG, whether you characterise them generically as government policy.
No, I don't.
No, but whether
Sorry, forgive me.
that's why I said whether. You see.
Yes, so I didn't hear that. Sorry. Yes.
Right, whether
Yes.
you do that, they are other material considerations.
Yes.
They're not development plan, and they don't have the status of
Correct. In law.
the development plan. Their status, if you like, for purposes of development decision making, development control decision making, they are other material considerations, and they're given appropriate weight by the decision maker within public law bounds.
Yeah.
All of which is basic, isn't it?
But I think there are references in other areas to national policy. So, for example, in the GPDO, for example. So the concept of national policy is recognised as in other aspects of legislation, not necessarily in Section 38(6) terms. It's not quite as simple as it being a consideration. But also, whether a local plan or whether a proposed development is consistent with national policy clearly is of importance in any context, on any rational view, is of importance in the Section 38(6) context. If it's a departure from, this goes to Mr. Justice Holgate as he then was as approach to the binding, that policy can't bind a decision maker. Well, that's right, so every policy admits of exceptions. But whether you're in accordance with paragraph 162 or not is clearly of fundamental importance to a decision. And it's very different to an argument that, well, we may not be in accordance, but there are material considerations nonetheless to justify a granting permission even though we're not in accordance with policy. Now, the whole point of national policy is to provide a steer, so it's clearly fundamental whether you fall within it or not. The other point, my lord, I do ask you to bear in mind this context. I'm just checking whether it's for you, but under, if I recall correctly, paragraph 35 of the NPPF. I hope that's the correct reference.
Sorry, paragraph
35.
35.
A proposed local plan must be, to be sound, must be consistent with national policy. I'm just checking if you have it. If not, I can provide it to you later.
Oh, that's the soundness test.
Actually,
I mean,
fortuitously you do on pages 15 and 16 of the supplemental bundle. That's by accident rather than by design, I think.
just a second. Yeah. Pages 15.
35. Yes. So, to be capable of being adopted ordinarily under paragraph 35, local plans are examined for soundness, and those are the considerations policy says. Now, you'll see D, consistent with national policy, is one of the things.
Yeah.
Now, it does then go to say, accordance with the policies in this framework and other statements of national policy. That, on a fair reading, the PPG is a statement of national. That's talking about written ministerial statements and the like.
You would include the PPG as a statement of national planning policy?
I wouldn't.
You wouldn't?
No, because the PPG supports the policies in the framework. Other statements of national policy are, for example, because the framework refers to it, the written ministerial statement on gypsies, other written ministerial statements. And the clue is a statement. The PPG isn't a statement. It's a website resource.
But it does state what it states, doesn't it?
Yes, but it's not, and in my submission, it's not a statement of national policy. It's not held out as that. And in fact, it's not even treated like that by the inspector. It's treated as informing an understanding of what the policies in this framework say. Right. That the testing, in relation to, so if one was going to look at, for example, is a successor, a new CS3 was to be promoted today in its form and be examined by an inspector in the context of paragraph 35, the question would then be, well, is it in accordance with paragraph 162? And that would have to be judged in my submission by reference to paragraph 162. The areas of focus, the considerations that may be given particular attention to, could be taken from the PPG. but one would stand or fall by reference to the framework. You aren't examined. And the key point is you aren't subject to examination for against the PPG.
No, but I mean, if the local plan inspector, or whatever they are now called,
they are still called that, for now at least.
said, I'm asking myself whether this policy in your local plan is in accordance with the policy in paragraph 162 of the NPPF, and to reach a sound decision on that question, I'm going to look at the PPG, which supports the NPPF by elucidating what it means. Then he can do that, can't he?
Subject to treating it as only elucidating, and that's the key point. So what the PPG could, so for example on heritage, he could take the approach I've set out in relation to the heritage passage, where it says, generally speaking, some examples are considerations to pay attention to. That's all fine. That is elucidation in the true sense of, that is guidance on the application of policy. However, treating as the inspector did, and I'll also show you that in a moment.
Treated as a straitjacket.
Treating as a straitjacket, exactly, my lady. That's doing something different.
Can I just try to understand in the context of D then?
Yes.
So you've got a local policy, have you, that you're considering, and you look at paragraph 162, and then on your case you look at the PPG as well, which we'll suppose sets out things you should have in mind when you're considering whether 162 is satisfied.
Yes. But not to the exclusion of other things. So it can provide a steer or focus. What it can't do is cut down the range of considerations that under the policy are material.
But it could still be that a policy that had been all right before the PPG was no longer all right because it didn't properly have regard to the relevant considerations.
No, I don't accept that. I mean, there's a danger, comes a point where we're talking too much, and I do need to take you to the inspector's decision to show, because this is the inspector's decision on wherever you calibrate the answer to these questions. I say the inspector went too far. But so, for example, it would be permissible for PPAG to say particular weight should be given in the context of considering what's reasonable, the following factors. But that's, again, different to what my lady Just Andrews called a straitjacket, which is it's that way or the highway. That's the point. It's not. It cannot be a binding constraint on on how you can achieve compliance with a framework policy. It can provide a steer. It can provide a strong nudge, but it cannot cut down the breadth of a provision in the framework. And that is what's done. On the inspectors and the judge's view, on any view, what has been achieved is that passage in the framework is identical in legal effect and consequence to inserting a new entry into the glossary of the framework, reasonably available means.
Right, so it can be a steer or a strong nudge, but it can't be stronger than
that's
strong
not. It might sound like sophistry, but it's not.
No,
It's
I'm not
legally
saying
important.
it's that. I'm simply trying to understand.
Yes, that is right, my lord. That is my case, absolutely. Can I now show, probably this is the junction to show you, because in my submission, when one properly characterises and understands how the inspector saw it.
Are we going to the inspector?
Yes, and then one sees it in the context of the decision.
So are we transitioning now?
We are to my section 2. We are exactly doing that, and that's page 213 of the core bundle. Right at the back.
Right, well, I've extracted it from...
Yes, sorry, not
No, that's
the
all
most
right, no.
obvious place to put the decision letter right at the back.
The trouble is, I
Apologies
still
for
have to
that.
find it. I've got it.
Normally you will find it right at the front. But
Where would you like us to go?
so could I ask you firstly, just to get your bearings, and do push me along if you're aware of this already, so page 213, main issue.
Well, if it helps you, we've
You've
read
read it and
the
marked it up.
inspector's
Fine,
decision.
okay, in which case I'll jump forward. So I can start with this section at page 214, development plan policy.
There is just one thing,
Yes.
if I may, which is a matter of fact. Are we right in thinking that and perhaps it is said somewhere in the decision letter, but are we right in thinking that the appeal site was open, undeveloped land in the countryside?
Yes.
There's no. I mean,
Yes. Yes.
there's nothing behind that question. Simply to understand.
No, that's right.
We're looking
Yes.
at
Yes.
we're looking at land which is not
It's not previously developed.
previously developed
No.
in any way.
Yes.
It's farmland.
Yes, farmland. Yes, as far as unless I've massively misremembered, it was
No, well, I mean,
fairly, in all other senses, it was a
I mean,
fairly,
the name of the site
yes,
strongly
it's a
suggests
pretty,
that
pretty
it's
good clue.
farmland.
Yes,
Because it's Lynchmead Farm.
yes, yes. In all other respects, it's a fairly vanilla candidate housing.
Well, it's a site that I'm not saying that is now very much normally developed, but it's a site that many of which examples are developed.
Correct. Yes, exactly. That's why it's a fairly run-of-the-mill candidate housing site in all other respects. So, my lord, in which case, my lord, my lady, paragraph 10, this section considers, as you'll have appreciated, the candidate sequentially preferable sites, how they performed against the CS3 criteria for reasonably available, the considerations that followed for the purposes of the sequential test in that policy. And you see at 14, the appellant argued that none of the candidate sites were reasonably available because they failed one or more of the criteria which were said to apply for the purposes of the test. And then over the page, at the end of 14, the inspector, though the council, he thought, didn't really take a point in this, so I need to consider how the candidate sites fare. I don't need to dwell on the reasoning. You can go straight in my submission to the conclusion at 22,
Yeah.
where he concludes that none of the sites were reasonably available in relation to the second section of CS3, which defined how reasonably available was to be applied locally for the purposes of the sequential test. So that was CS3. Then at 23, and this is a particularly important passage, moving on to consideration of national planning policy, the second section of CS3, and the next word is important, now, and the word after this is important too, inconsistent with the framework. Now outside the range of reasonable applications of the framework. And the word now makes clear, and this is not just me picking on one aspect of the decision, the rest of it's at a piece. The effect of the PPG is to make inconsistent that which was previously consistent.
And is that not permissible? Is that not permissible?
No, that's not elucidation. That's straitjacketing.
Well, suppose to forget the PPG for a second, and just focus on the NPPF. If you've got a development plan policy which, as it were, incorporates the NPPF, and I add the words "for the time being," and then the NPPF subsequently changes, can that not have the effect of changing the way in which the policy operates?
If the NPPF changes, yes.
Yes.
If
the NPPF changes, yes, but not if the PPG changes one's understanding of the NPPF.
Yes, sorry, forgive me if I misunderstood the question. If the framework changes...
no problem, but if the PPG sheds such light on the framework as to give it a different meaning,
yes.
That's not all right.
Yes, because that's not just shedding light, that's changing the meaning. It's not shedding a light, it's not providing a steer.
You can't. Sorry, that's eliding two different concepts. What my lord is putting to you is that the NPPF is unclear. The guidance clarifies it. The clarification may mean that the understanding of the NPPF is different as a result of the clarification, but nevertheless it then turns out that the misunderstanding has been reflected in the local policy.
But with respect, Mary, it wasn't unclear. It was broad and open textured. And that's the point. It wasn't unclear.
But we're sticking with my lord's hypothesis for the moment,
yes.
Not with the facts of this case. Surely you have to accept, as a matter of theory, that if the clarification makes clear that which was muddled before, and the original local policy is in accordance with the muddle, then the clarification could result in the local policy being interpreted as inconsistent with the framework. Seems to me that that is an inexorable matter of logic.
I think even if that were to be the case, and
You say that's not this case, but...
Yes, I mean, I hesitate, my lady.
Of course you do.
I hesitate. The reason I do...
It's not helpful to you.
Well, it's
I
not helpful, but also
understand
it's inconsistent with the learning of the cases, which I'll come on to, which they don't bind you. They are, I say, illuminative. And the reason why I hesitate is this: is one does have to exercise real caution for the Mr. Justice Leven reasons about treating something that could be stuck up on a website, doesn't go through the same process. For example, the framework, leading counsel, no secrets, Rupert Warren, everybody knows that. He published the Rupert Warren, advised on every single framework and has helped advise with a team of juniors on the drafting. That's not done with the PPG. So one does have to exercise real caution about something that could be stuck up on a website with potentially a very junior civil servant writing it as somehow redefining the meaning of a document that's subject to public consultation, been through lawyers, an army of government lawyers, etc. So might it in principle, I'm not conceding that, but maybe, and I say I'll come on, might it in principle, particularly if it's 10 years later in this case. The PPG here was published in August 22, 10 years after, to suggest that that somehow clarifies what was intended by totally different people under a different government 10 years prior. It's a bit of an ask.
So what does the
even
PPG,
if it's legally possible.
What does paragraph 7028 do then, you say?
78028, properly understood, provides a focus of what may be particularly important but not exhaustive considerations.
I think I need to note that, actually. It provides a focus of, or for, what was it?
Of important but not exclusive consideration. So had the inspector gone on to consider whether CS3 was, well, he did actually say CS3 was previously a legitimate application of the framework, so in a sense that he didn't need to go further on this case. But this wasn't a case where the inspector, as I'll show you once I go through the other passages, because they obviously have to be read together, this wasn't a case where the inspector, on the particular facts of the case, weighed the PPG advice and said, well, though there may be other considerations, these are the most important ones in these circumstances, doing what I say the job of heritage guidance does. He said the PPG redefines. He uses on more than one occasion the words define, now inconsistent, with the straitjacket.
I'm sorry to draw you back, if I may, just because I think it could be important later on. Paragraph 7028 provides a focus of important but not exclusive considerations.
Not exhaustive, I think, but same point, yes.
Oh, it's exhaustive.
Exhaustive. It can't be a... it can't constrain the range of considerations relevant for compliance with the framework.
So it was. I was going to ask you what comes after considerations.
Yes.
So the words relevant to
compliance, or otherwise as paragraph 162. It can't constrain or cut down, as I say, it was treated wrongly below as. It can't constrain or cut down the range of considerations relevant under the framework. What it can do is say within the range of considerations under the framework, these are ones to focus on.
So it could still have made CS3 wrong, could it? Because it would have identified considerations to which you ought to have regard, and they wouldn't necessarily have been taken into account.
No, it couldn't have done that. The reason why is, imagine the PPG wasn't, firstly, that's not the inspector's judgment, now inconsistent. So actually, that's just not the analysis below, and there's no respondent's notice. But be that as it may, think of it in public law terms as planning judgment. CS3 was a rational, Wensbury reasonable planning judgment at the time of an application of national policy to the local circumstances. How the inspector, and therefore, and that's perfectly legitimate, one of my points, I say I'm slightly jumping ahead, it's always the way, but is that it's perfectly legitimate for a local planning authority to set its own local application of national policy, provided it's within the range of rational applications. And the breadth of that range will depend upon a number of things in the usual way, such as the breadth of the language used. Reasonably available, as the judge below said, is broad, open textured. What the PPG can do is, if that local development plan was being examined today, it could provide, within that broad range of relevant considerations set by the language of 162, it could say particularly important considerations to bear in mind are A, B and C. What it can't do is say the only considerations to bear in mind are A, B and C.
So would this be right if you were formulating CS3 after the PPG, which on this hypothesis had set out a list of considerations? What we see before us as CS3 might turn out to be wrong, but because it predated the PPG, it was all right, because at the time that list of considerations didn't exist.
I'd say wrong perhaps wouldn't be quite the right term, but it may not have, if the examination was done now, the examination, for example, might say, firstly we're going to look at the PPG, and does this policy, does it give effect, does it have a proper regard to the considerations that the PPG said are main areas of focus? And then the examination, well, are there any other reasons why it's nonetheless consistent with 162? That's not how it was treated by the judge below or by the inspector, because they stopped at that first stage. So the way I invite the court to look is the range of reasonable applications and what the PPG has done on the analysis below, in my submission, impermissibly, as to narrow that range of reasonable application, local applications, so that what was previously within it now falls outside it. And that, in my submission, that is the proper and indeed fair characterisation of the decision letter. And then the question becomes, is that in law the proper objective interpretation of what the PPG is doing? Which is a different question to the source of the power. May I, when you've completed your note, my lord, just take you through the particular parts of the decision letter I draw attention, because I wouldn't want to be accused of over-relying on one word or two words, so that's all at a piece. So come just give you a trot through the passages.
Of course.
24, reasonable rail sites are defined as those, etc. Then...
So nothing wrong with that?
No, I don't know there is something wrong with that, because the PPG can't define the definitions.
I see. So defined is...
And I said, I'm not, if that were the only reference, if there was, then obviously one has to read it fairly as a whole, but there's a pervading theme here in my submission.
So why is defined wrong there?
Because defined, as the inspector treated it, meant...
so he meant, when he said defined, he meant confined?
Yes, correct.
So if you read defined as confined,
as an exhaustive
he would be wrong.
He treated...
you need to read a word in, exhaustively defined.
No, in my submission, I don't, because it's clear at a piece, because that's why he says now inconsistent.
Depends how you define defined.
Yes, well, it depends how you define it. But then again, you go back to the glossary. The framework has definitions, and they are exhaustive. If one looks at the glossary of the framework, he's treating 7028 here as...
So the error in 24, you say, is the use of the word defined.
Yes, but it's not a semantic point, it's a substantive point.
It's a substantive error.
It's reflective of the consistent approach, as I'll show you when I take you through the whole. To read it as a whole, I have to take you through it as a whole.
All right.
I can't help but think that this debate suddenly sort of brings into my head all these judicial dicta that one doesn't read a planning inspector's decision letter as if it were a statute.
Yes. Well, that's why I'm taking it through it all. I've only on the second reference, my lady, of about 15.
We're picking over one word.
But I'm not. That's the point. As I have to take you through the whole passage.
You're not picking over.
No, I'm absolutely not. If it was the only use, but
Right.
it's in substance. What is the inspector doing here? And you do actually have to read the decision to. The words do count for something. One doesn't just. One's not over legalistic.
Well, we'll.
If the words didn't count, there wouldn't be a need for a decision letter.
We'll listen to the other.
So
points
there's
on
then.
the other paragraphs.
The Kane, for example, at 38.
Are we going on to that 38?
Yes, I'm going to come back to 24, but on the defined point, 24, you see at 38, the last line, there are still many alternative sites that would meet the framework definition of reasonably available. So he's treating, which is the PPG definition, not the framework definition, he is treating 7028 as defining for the purposes of paragraph 162 what reasonably available means. And that's not just a semantic point, because when one reads this passage out wholly and fairly, that is clearly the substantive effect. It's not just formal, it's substance. Going back to the passage at page 216, DL27, second sentence, because of the inconsistency between the documents, and by that he means the inconsistency at this stage between CS3 and the framework as to what is meant by reasonably available. And that inconsistency, reading that in conjunction with 23, is because of the PPG. So again, you read that at a piece with the references to definition, it's clear that the inspector is treating 7028 in substance as for setting out a straitjacket on how you do or don't comply with 162, not simply giving a steer of things to pay particular account of.
What do you make of the word weight? He gives lesser weight.
Yes, well there what he's doing is saying, because CS3 is now inconsistent with the framework, my next step in the mind map is to weigh, on the one hand, the framework versus 2 CS3, and I give more weight to the framework. If I'm wrong that the first step was illegitimate, there's nothing wrong with that second stage. But the antecedent question is, well, was there an inconsistency in the first place? Then also, you see also in that passage is the new and more up-to-date framework as interpreted by the PPG, at a piece again with my characterisation. And then at 37, again you see many of the alternative sites fall within the meaning of reasonably available in the framework as set out in the PPG. Nowhere is there any suggestion by the inspector that he thought there might be some other residual considerations beyond the PPG. It was the PPG very much operating as that straitjacket. DL39, you've already seen 38, framework definition of reasonably available, 39. CS3 on the one hand, and then something which he sees as inconsistent, though CS3 he accepts was consistent, the framework as informed by the PPG on the other, etc.
So the error in 39?
Well, reading 39, I mean, it's one error pervading the whole decision, which is, so it's not, I don't really zoom in on it.
No, but how is it manifested in paragraph?
How it's manifested in 39 is he's treating reasonably available in 162 as being defined by the PPG.
So does it centre on the words interpretation of the wording of the PPG, is that it?
In 39,
Yeah.
That and the words that follow, because he's contrasting CS3 on the one hand, which earlier he's accepted is only inconsistent with the framework now, it having previously been consistent, and the framework as informed by the PPG. The only thing that's made the difference here is the PPG. And I need to show you in a moment the arguments that were put by the council, because more light will be shed on this, because as we know from South Bucks, you read decisions in the context of the arguments put, because they're addressed to the parties. And so in a moment you'll see the submission made to the inspector, which was ultimately accepted, the council's case, that sheds further light on the proper characterisation of this. I think probably I can take the rest of the thread, but what I say is I'm not so much nitpicking on individual words, but saying there's a golden thread here in the manner that I hope I've made clear what my case is, the proper characterisation.
Fine.
Can I then make the following submissions in light of that? Some of these I've covered already, so I'll be...
So are we just...
So I'm now on the... It's still within section 3, but having taken...
Section 2, I think.
Sorry, section 2, my apologies.
Yeah.
And I've moved away from the decision to the proper characterisation of it. Obviously, I've dealt with that as I go along. So just to be clear, point 1,
Yeah.
perfectly legitimate for a local authority through its local plan to set out how a national policy will be applied in the specific circumstances of its area, subject to rationality. That's obviously what CS3 did. See the words for the purpose of the sequential test. That was the North Somerset application of the predecessor to 162. It was a rational application. It was within the range of reasonable responses to national policy, which has been the same since at least PPS 25 in March 2010. Second,
that's a matter for the LPA, not for the court.
yes, but that's a point in my favour in a sense.
No, I'm not.
Yes, that is.
I'm
yes.
not thinking
Yes.
whether it's in your favour.
Yes, yes,
trying
that's
to get
right.
it right.
For the LPA, subject to obviously the inspector examining the, because it's for the LPA, and then the inspector's got to examine the local plan, and then the plan is adopted. And once the plan is adopted, can you imagine, my lord, for example, if I came before this court or the planning court in 2013 and sought to challenge CS3 on the basis.
You couldn't have done this.
couldn't
It
have
didn't exist until 2014.
Well, 2014, forgive me. Yes. I've taken the DeLorean back 1 year too far. But
March 2014.
if I was to go in March 2014 and come to this court or the court below and seek a statutory review on the basis that it was outside the range of rational responses to the relevant national policy, I'd be sent packing. And that's my point.
Politely, of course.
Politely, of course. Of course.
Right, so the substance of this point is that what CS3 did was all right.
Yeah.
Because it was a manifestation of the local plan setting out how government policy should be applied.
Exactly. And the PPG on the inspector's analysis changed that position. So second point is there's been no, as we know, no material change to the terms of national policy as the inspector recognised at DL23.
Yeah.
Thirdly, as I said a moment ago, the inspector's decision needs to be read in the context of the arguments before him by the parties to whom the decision was addressed. As to which, could I invite you to take up page 46 of the supplemental bundle? This is the closing submission of the local authority. And the submission that I say on a fair reading the inspector agreed with. And at 18, corresponding in my submission to the finding at DL23 and following, the third sentence, if the MPPF is viewed in isolation, it's impossible to assert the detailed criteria of policy CS3 conflict with the Secretary of State's policy. And then 19, however, the Secretary of State hasn't confined his exposition of the sequential test to the MPPF. He's published detailed guidance on how it, and I emphasise this word, ought to be applied in 7028. And that, in essence, is the submission that I say the inspector accepted, obviously in his own words and his own way in the paragraphs I've taken you through, i.e. CS3 is within the range of reasonable applications of para 162. However, what happened in August 22 is that range was narrowed so as to exclude CS3 from the range.
So you take issue with the word ought.
Yes, because again, that's at a piece with how I say the inspector treated the PPG, which was as a straitjacket to how one is able to achieve compliance with 162, as opposed to a guide or a steer.
So meaning that could say can be applied or may be applied.
May.
Yeah.
So if he said may, it would be all right.
Yes, I think it probably would. I want to reflect on that because that's not quite how I formulated my submissions. But,
No, but I
subject to any qualification I come back on, probably would because that's not a straitjacket. Still keeps the range wide, but is providing a focus.
So, may, should, can. Where do you draw the line?
Well, again, it goes back to, I'd say, the way I hope I don't sound like a broken record, the parameters of acceptable or permissible applications of 162 are defined by 162 alone.
Yeah.
And then, and that cannot be changed by the PPG. No. What the PPG can say is where within those parameters particular attention should be given. It can't move the goalposts. That's the point. I'm mixing my metaphors, but I hope it's clear what my case is. I obviously develop why I say it's my case as I go through my submissions.
Yeah.
Right. Can I then?
So you've made those submissions. Three submissions.
I think I've made my case sufficiently clear on the character. I think it's hopefully clear what I say. The proper characterisation.
Yeah, you say, in simple terms, I think you say the inspector wrongly put himself in a straitjacket because he took the PPG to require him to do that, and he was wrong to do that.
Correct. Or as I put in my sort of notes to self, what the decision letter did is gave the PPG the effect of setting out binding criteria which must be satisfied for there to be a finding of compliance with 162. Binding criteria which must be satisfied, words chosen carefully by me, binding and must, for there to be a finding of compliance with 162. And that amounts, in my submission, to redefining the term reasonably available, not elucidating it, but essentially inserting terms in the glossary of the framework, defining that term, which aren't in the framework. And our case, just to be clear in terms of how the grounds of appeal is, our ground 2 is that in holding that what the inspector did was simply treat the PPG as elucidating, Mr. Justice Holgate mischaracterised the decision. It was more than elucidation, it understood as meaning guidance for the reasons I've given. And under ground 1, I say what the inspector did do on a proper characterisation was impermissible. And my learned friend says the two grounds both have to succeed. That's probably, provided that elucidation understood as meaning guidance, probably right. I'd accept that. There's an interplay between the two.
Well, there's quite a strong interplay between.
Yes, there is.
I mean, I don't know whether it's an overlap, but I think they do.
Yes, my lord, that's right. And it
strongly interact.
It reflects the judgment. If I just ask you just to show you this point, because it may hopefully deal with the act of point about academic on the head. One goes back to the judgment, page 89, paragraph 141, and the grounds of appeal correspond to the latter part of paragraph 141 of the judgment, where Mr. Justice Holgate says there's no legal principle which prevents national policy in a framework being altered by the PPG. And in any event, that's not what the inspector treated it. He treated it as elucidating. Well, ground 1 attacks the first of those statements. Ground 2 attacks the second. So it's not academic. It goes directly to the heart of the analysis of the judge. And the grounds were drafted specifically with that concluding passage in the judgment on the Mead appeal, the Mead challenge, in mind. So, my lords, if it's convenient, I was going to move to stage 3 and just take you through the case law. I'm very conscious. I don't want to over-labour high court case law in the Court of Appeal for obvious reasons.
Well, we've read the cases and we know what the judges said.
Yes.
And we know the contexts in which they said what they said.
Yes, well, I mean, in that case...
Does that help you?
Yes, I think it probably does, in which case what I might do is give you my headline submissions, and then I think I do need to take
No,
but
sure.
I'll please do move me along, because I don't want to bore you.
No, I wasn't expecting you to say, in response to what I said,
Yeah.
that you didn't want to go to the case law, but I'm simply saying it because it may guide you
Yes,
as to
you're
how
not flying
much
blind.
of it you need actually to read out to us.
No, understood, thank you. Well, if I'm telling you at any stage what you're already aware of, please do say. Headlines, my lords and my ladies, are this, that my learned friend Mr. Flanagan, at paragraph 32, you don't need to turn it off his skeleton, reflecting what the judge below said at paragraphs 87 to 92. So, respondent skeleton 32, judge 87 to 92. They suggest that these cases are context specific, confined to their facts, and don't establish or concern any general principles. And what I say in response to that are three things, and I ask you to bear these in mind when I do the tour through the cases. So one, that's a plain misreading of the judgments. Two, it overlooks that Menston actually concerned flood risk in the very same paragraph of the framework.
Sorry, what was that one again?
Menston, that's Menston.
Oh, I see. Yes,
actually concerned different context, but it's a different issue, but the same paragraph and the same context. And thirdly, in my submission, in any case, and these are alternative as well as cumulative arguments, thirdly, there's no coherent, principled basis for holding that there should be a different approach in those contexts than there should be in the present context. So it's incorrect reading of judgments. Menston actually isn't a different context, and thirdly, no coherent basis for distinction. And those are the 3 points I just ask you to bear in mind as I take you through the cases.
Right.
What I do, I deal with the High Court cases chronologically. I'll deal with Braintree at the end because it was overturned.
Well, Braintree, I said what I did, and
You did.
but it was overturned.
Yes, and you'll know what you had in mind better than me, obviously.
Well, I hope so. No, well, I mean,
Yes, if you can remember.
it's possible, yes.
So can I start with Menston? I'll give you the skeleton references just for your notes as I go along, but I don't... So Menston is Authorities, tab 6, my skeleton 19, paragraph 19. And the key point in Menston, summarised in the head note D to F, and also in the judgment, but I think I'll summarise verbally, is the PPG required, the PPG that corresponded to the paragraphs that include what's now 162, required consideration of how to reduce existing flooding, whereas the framework talked in terms of only not increasing flooding, as opposed to dealing with an existing problem. The development in that case had been assessed on the basis it didn't increase flooding elsewhere. The claimant said, hang on a minute, what about the mitigate existing problem? The judge said the PPG couldn't, was subservient and couldn't impose additional criteria. That is a very, very high level précis, but I hope helpful for present purposes. Can I ask you then, against that background, to look at 21 and 22 of the judgment? Starts at page 132 of the authorities bundle, 478, and over the page at 133 you see the framework paragraphs, and you see 101, which is now 162, one in issue. Steer new development to areas of lowest probability of flooding, etc. And 103 continues, ensure flood risk is not increased only elsewhere, and only consider appropriate areas of flood risk in where there's a sequential test, etc. There is then a quotation at paragraph 22 of the judgment from the framework, and you see the relevant formulation in the judgment. What are the opportunities for reducing flood risk overall? Local authorities and developers should seek opportunities to reduce the overall level of flood risk in the area and beyond. Then at 24, you see a summary of the grounds of claim. Ground 1 is the contention the council misinterpreted the relevant policies, the framework and the PPG. The council based their consideration solely on the question of whether the development proposal led to an increase in existing flood risk as opposed to reducing. Only, is it going to make things worse as opposed to does it do its best to make things better? Then continuing a little further along at 36 on bundle page 139, report page 485, you see at 36 the case summarised again, that you had to, and note the way it's put, the correct interpretation of those paragraphs of the framework when read in the context of the PPG, not dissimilar formulation from how the case against me was put and the inspector's approach, and indeed my learned friend's approach. Then the case is re-summarised. 38, real question in this case is whether or not the framework and the PPG require, in the development control context proposal, seek out and provide opportunities to reduce flood risk. In my view, it's clear when you read the framework that they don't. I'm summarising. And then 40, when I say, well, ditto 162 doesn't, when you read that in isolation, CS3 falls within it. So again, I analogise. 41, the paragraph of the PPG is first obviously subservient, and I say correct. That's how the framework is, if you like, pitched. See the Taylor review, see the way it's published, see the name, see the lack of consultation. All of those things put in the round inform the Tesco and Dundee in proper characterisation, interpretation of the PPG, which is indeed subservient. And then he goes on to say this: thus, if I'm satisfied, the framework does not include a test when decision-making which requires the seeking out of opportunities to reduce the causes and impacts of flooding, the text within the PPG cannot override that reading of the primary document. I probably don't need to spell out how I analogize that to the present case. It should be obvious what I draw from that. And noting primary document.
Was he discerning some tension between the two?
Well, to the extent that the PPG introduced a test which wasn't necessary for complying with the framework when reading the terms of the framework on their own.
Well,
Yeah.
putting the question a slightly different way. Why does it matter whether or not the PPG is subservient to the NPPF? Why did that matter?
Because it can't introduce binding criteria for the purposes of considering whether one complies or not with the
No,
framework.
but why did it matter in that case?
Because the framework didn't have a test of reduced flood risk elsewhere. It was
the framework. So this was not a case in which the PPG was purporting to elucidate the NPPF.
Well, that's not how the judge analysed it. How he analysed it.
Well, that's why I'm asking you.
I mean, on depends how it does go. I don't want to be semantic. Depends how what one means by elucidate. Because in my submission,
Well,
the approach to the
all
judgment.
right, let's use a more common English word such as explain.
I mean, in terms of the judge below's approach, the judge below would have said, well, in my submission, on his analysis, the PPG in the Menston case was elucidating the framework. It was corresponding to it. It was adding colour to it. Yes, it may have added criteria that weren't in the framework, but Mr. Justice Holgate didn't have a problem with that. So I wouldn't accept that there is a distinction.
Right, can I to be absolutely clear? Sorry, it's probably because I've been slow about this. When we look at the first sentence of paragraph 41,
Yes.
and we see the expression obviously subservient to the
Yes.
policy, he's referring. Which paragraph of the PPG is he referring to?
He's referring to the one quoted at 22, the judgment.
Right, I'm sorry to take us back. I just want to be clear.
And the policy for which it provides practice guidance is the
Right.
bundle of paragraphs referred to immediately above.
So he's referring to paragraph with that great long number. He's referring to the paragraph headed, "What are the opportunities for?"
Correct. And the
That-
policy for which it provides practice guidance is the preceding collection of 3 paragraphs quoted immediately prior.
Right, so that's the passage of the PPG.
And it is specifically said to be, as the introductory words of 22 say, guidance regarding implementation.
Yeah, but I'm trying to relate now to the policy to which he's referring at 41, which is
That's the policy that's quoted at paragraph 21 of the judgment.
And the tension is it between the reference to reduce in the PPG, as quoted in paragraph 22, as compared with not increased
Yes.
in paragraph 103
Yes.
of the
Yes.
framework.
It's introducing a further requirement.
Is it a requirement exactly?
Well, that's how it was treated by
Yes.
the claimant in that case. I think that word
you've got
used.
to.
Something was can I just finish taking you through the passage of 41?
Well,
Because that
Please
might
do,
show-
but
Yes.
just to help you, I've underlined 2 words,
Yes.
among others, but I've underlined the words "not increased" in paragraph 103,
Yes.
and I've underlined the words "to reduce"
Yes.
in the PPG.
Yes.
Sorry, if I said not increased in the NPPF and to reduce in the PPG. Now, on the face of it, perhaps there is some tension between those 2 concepts. They're not obviously easily reconcilable. And it may therefore be, this is merely to reason it through for your comment, it may therefore be that the judge did find it necessary, where he was considering that tension, to resolve it in favour of the NPPF or the PPG, and he did that clearly in favour of the NPPF.
What I would say in relation to that is the tension may be more superficially or nakedly obvious because, well, for the reasons you've given, one says not increase, it's reduce. I mean, it's kind of in neon lights. There's a very clear tension. Analytically, it's not distinguishable from the approach of the judge and the inspector in this case, which is before wide range CS3 within it, afterwards narrower range CS3 outside it, because of the PPG, and therefore the PPG on the approach of the inspector, which is to treat the PPG as being binding, etc., is exactly to the same analytically, which is there's a tension. PPG is saying the only way to be reasonably available is this way.
Yeah.
NPPF saying there's a range of different.
Yeah, but our focus here, in the first instance, is on the relationship between NPPF and PPG,
Yes.
and that is one consideration for us. The other consideration for us is the relationship between that relationship, if you like, on the one hand, and the development plan policy on the other.
Yes.
There are two dimensions.
Yes.
And the parallel dimension in Menston is the relationship between NPPF and PPG. And it's that phrase, not increased, and that phrase, to reduce, that the judge is ultimately considering when he says what he does at paragraph 41.
Well, that's right, but it's the relationship between the PPG and the NPPF that directly inform the inspector's analysis of the relationship between the NPPF and the development plan. So in both cases, the critical step, the thing that made the difference, was the same relationship, namely that between the framework and the PPG, because it was the PPG in this case that now inconsistent, that made the framework different than it was before.
And you're obviously right that in Menston, again, it was a question of whether a range was being narrowed. Where there might be said to be a difference is that reduce is not explaining not increased. It's different.
I'd say that's a distinction without a difference. I mean, as I say, it's a more obvious contrast because in terms of language, one can see it much more superficially, obviously. But analytically, it's the same because what the framework is doing, what the PPG in the inspector's approach is doing is, in his own terms, redefining reasonably available. Now, redefining something is changing it. Not providing guidance on how you might go about implementing it, it's changing it. What was previously permissible is no longer permissible. However you describe, whatever metaphor you used, it's analytically different from elucidation, analytically the same as changing, not increase, to reduce. And on the judge's approach, which is same source, no need to consult, PPG can create policy, the PPG could quite legitimately have introduced a new requirement, not reduce. And I'd stand back as well. There's a point I would like to make, but I'm making that case I forget, that the approach of the judge and my learned friend, the inspector, makes planning more complicated. I'm well aware, my lord, Sir Keith Lindbom, you've tried over the course of your judicial career to make planning less complicated and more straightforward. Actually, the approach of against me leads to far greater complication because you have two rival corpuses of policy. Rather than the policy and the guidance on its application, developers, landowners, local authorities now have to search around in the PPG, work out, is this changing the policy? Is this just hallucination? Is this not? Rather than having clear boundaries. So actually, if one goes back to like my lord's overall, if I may be permitted to say, commendable philosophy of making planning more straightforward, that tells in favour of my case, not the other. And the discussion we're having illustrates that in my submission, respectfully.
Right.
Can I just finish 41?
Please do, yes. Sorry, it's my fault, because I did just want to take us back to that.
Go down rabbit holes, hopefully they're helpful rabbit holes. So we were at 41D on page 140 of the bundle. Obviously, I'd taken you to the passage running up to primary document. Then just carrying on, because there is some more relevant material, the text and the PPD does not undermine the proper interpretation to provide for separate tests. Again, it should be obvious why I rely upon that. Not to say the PPG couldn't be pertinent, but it's pertinent as a general consideration, not as a question of do you or don't you comply with the framework. That's not how the inspector in this case saw it. He wasn't treating the PPG as a general material consideration. It was the pathway to compliance with the framework. Not a pathway, the pathway. So he goes on to say, no doubt proposals to offer as a benefit reduction, that would be a positive consideration, but there's a difference between that approach and treating it as a policy requirement for the purpose of the framework. In short, whilst it's not a breach of the framework paragraphs, the proposal not to seek to make flooding better elsewhere, there can be a benefit.
Yeah.
And I say that the approach of the court below does seek to treat the framework as, to use Mr. Justice does approach, overriding the PPG. Can I now turn to solo retail? I'm sorry that the pages aren't quite in chronological order, or not at all in chronological order in the bundle, but it's page 13, sorry, tab 13, my mistake,
Afraid
page
I don't
279.
have tabs. 279.
279, that Mr. Justice Leven.
Yeah.
And here, paragraph 3, it was a Store Wars type challenge, one retailer seeking to challenge a incoming rival's retail permission. At paragraph 5, you see that the crux of the judicial review was the approach to retail impact assessment.
Yeah.
Paragraph 10, you see the relevant NPPF policy. And you see that in the circumstances set out in the third and fourth lines, local authorities should require a retail impact assessment if the relevant threshold is considered, and it sets out what the assessment should be about. Then at paragraph 12, over the page at 282, you see the PPG, and B, how should the impact test be used in decision making? There's discussion of that.
She calls it planning policy guidance. Actually, that's not right, is it? Because it's planning practice guidance.
Yes, and it's not national planning policy guidance. This was, I think, fairly early on before people got perhaps completely to grips with the PPG. Yeah. But no, it's the planning practice guidance. No N, no national, and it's. Yeah. D, is there a checklist for applying the impact test? And that's set out. Pausing there. This is closer to home in the present case, in terms of not a direct clash in the sense reduced, not reduced, but more in the nature of what might on its face look like elucidation.
Yeah.
I say on its face, obviously. Then at 20, oh sorry, forgive me. Also, just note in the checklist, the fourth bullet at the top of 283, there's reference to convenience and comparison goods. That just provides a bit of context for how the arguments are put forward later. Mm. Then 23, starting at 289, really over the page, the grounds. And you see the first grounded challenge, misinterpreted, amongst other things, the MPPF paragraph 89, which was the paragraph on retail assessment. That's the top of page 290. And you see at 24 that no retail impact assessment, it said, was carried out in relation to the convenience elements of the proposal, which was both convenience and comparison. Mm. And he says there was a policy and legal requirement for a full retail assessment, including the convenience element, by reference to the passage of the PPG that we looked at earlier. Yep. And then you see that again at 26. Mr. Neal, for the claimant, said an impact assessment must mean, sorry, I missed out the words, an impact assessment within the MPPF must mean that one that accords with the guidance of the PPG. In particular, the passage I've taken the court to. And again, that is closer to the elucidation type argument, broad policy for retail impact assessment, guidance on how that is to be undertaken. Is that a straitjacket or is that a nudge? Answer, a nudge, not a straitjacket, in essence, is how the judge dealt with it. We see it 291.
A nudge, not a straitjacket.
A nudge, not a straitjacket. So you see 32, paragraph 8, we don't need to be concerned about this emerging development plan policy, but paragraph 89 of the framework does not say what an impact assessment could contain. I interpose 162 of the framework does not say what reasonably available is. How is it to be defined? Self-evidently a matter of judgment for the council, I say pre-PPG. Self-evidently CS3 was a matter of judgment for the council applying the national policy. So then Mr. Neal has to fall back on the PPG, and in particular the detailed steps for an assessment. So I think Siri's commenting on that. Then, in my view, the PPG has to be treated with considerable caution when the courts be asked to find there been a misinterpretation of planning policy. Then there's the observations that I've mentioned, the skeleton that you're familiar with. PPG is not consulted upon, unlike the MPPF, no external scrutiny, let alone the MPPF, let alone development plan. MPP is not drafted forward by our lawyers. All the points that I've made already. No public system for checking for inconsistencies or tensions. It's intended, as its name suggests, to be guidance, not policy. Must be considered by the courts in like that. That's my test quandundum. It's not just about the source of the power, but how you construe it. How is it? What's its intended function objectively? And so on. And then at 34, Mr. Justice Leven says these points are illustrated by the relevant paragraphs. Now, pausing there, in my submission, it's clear that 33 is a statement of general principle, not confined to the facts. 34 then turns on the judge's own language, turns to the specific paragraphs of the PPG. These points are illustrated by the paragraphs that are most relevant in this case. Very clear on a fair reading of Mrs. Justice Lever's judgment. 34 is the context-specific application of the general principle set out at 33, contrary to the, with respect, misreading of the judge below and my learned friend of this being purely fact-specific. And if I say, if the inspector had allowed this appeal, my appeal, on the basis that the appeal scheme was compliant with policy CS3 and the MPPF, and if somebody had brought a section 288 challenge for statutory review on the basis of a failure to comply with the PPG, precisely the same analysis would have applied.
So just, you say paragraph 33 is the general principle.
Yes.
And we see in paragraph 33 that the PPG has to be treated with considerable caution when asked to find there's an interpretation of planning policy under paragraph 18 of Tesco and Dundee. So is your proposition considerable caution? What is the general principle?
Yes, so there's, I'll deal with now. I was going to pull the principles together because all the cases kind of synergize together. But it can never, in my submission, although I don't actually need to go this far to make good my case, but this is what I say one can derive, it can never redefine. It cannot change the framework. It cannot, in relation to 162, narrow the parameters.
Well, you say it can never redefine, but can it?
Define. No, sorry, I forget re. It cannot change the framework.
Well, you are saying it cannot define.
Define, yes, I am. It can provide a steer. So when you have a broad concept, broad terms such as reasonably available, or such as the sequential retail impact assessment in this case, the PPG cannot change the parameters of the policy. What it can do is provide focus on where within those projects. That's the one. Sorry,
No. Well, sorry, it's my fault.
There's a but coming up.
To indicate, I want to ask you a question. I want to be absolutely clear. Are you saying that paragraph 7028 of the of the PPG, exceeded the proper role of PPG?
How it was treated.
Yeah, but so the answer
the
answer to my question is no.
No, properly understood.
Right. So I think we really do need to be clear on this.
Properly understood. While superficially it looks like it might be saying things in a binding language, once it's read in the context of how the PPG is packaged, what the PPG is doing, it's not binding. No more than the retail PPG, which was in similarly, ostensibly mandatory terms, but once properly understood and put in its proper box and role.
Right. If that's right, then the crucial question in this case is whether the inspector and in turn the judge got that wrong. In other words, misunderstood that PPG paragraph 0728 was doing what it could do. That must be the crucial question.
Just run me past that again so I've understood the question.
Perhaps I put it poorly. I'm sorry.
I think the answer is yes.
If properly understood, that passage of the PPG did not exceed the proper role of PPG, which I think is what you've just said. Properly understood, I emphasise, it did not exceed the proper role of PPG. The crucial question in this case, now before this court, is whether the inspector misunderstood what that paragraph of the PPG was doing.
If I've understood the question correctly, and I'll explain one thing, that's right. It's not quite how I would formulate it, but yes, with that subject to that proviso. By that I mean 7028 could only ever be truly elucidating, by which I mean providing a steer on what were particular considerations. It couldn't, as a matter of law, be more than that. Just no matter how it was worded. Just as the retail impact assessment guidance in solo retail, although it was set out as a checklist, you want to go back and have a look at it, It's at pages 282 and 283.
I'm not sure Mrs. Justice Lieven goes that far, does she?
Well, I was going to get on to a
Yes.
but in a moment, so because there's a distinction between redefining and interpreting, and I want to come to that. Not quite conceptually the same thing, which is, I think, the answer to my lord's question. But if one just on this point that my Lord England mentioned,
Yeah.
D, is there a checklist? The following steps should be taken. Superficially, that is might be taken to be a sort of mandatory pathway to compliance with the corresponding paragraph of the framework. And the point Mrs. Justice Lieven, or certainly the point I invite you to conclude Mrs. Justice Lieven was making, and in any event the point I make, is PPG can't provide a binding pathway, a mandatory, exclusive or exhaustive, however you phrase it, pathway to compliance with a framework policy which is broader. It can only provide focus. Interpretation slightly different.
Just pausing there. Does Mrs. Justice Lieven say that? I'm not sure she does.
I
She says in 33, well, you've got to treat it with caution. And then when she comes to 34, she, with that in mind, interprets the PPG. And she says, well, you might take this as mandatory at face value, but actually you don't.
Well,
So she's not saying you can't do a certain thing. She's saying, here it's not being done.
Well, when we use it in context with 34, the last line, paragraph 017 cannot and should not be interpreted and applied in an overly legalistic way as if it was setting out mandatory requirements.
So she's saying it's not setting out mandatory requirements.
And it can't be.
Well, does she say that? I'm not
Well,
sure she does say
I
that.
invite you to conclude. As I say, what I want to do is pull together all the
Yep.
principles in all the cases, because they all look at things in slightly different ways. But I say when one reads this in conjunction with the Mr. Justice Dove judgment and the Mrs. Justice Lang judgments we come to, pulling all that together, the subservient document cannot change, cut down from the meaning of words in the primary document. Now, which, however you calibrate what that submission means, in this case, the inspector went too far, now inconsistent with defined, etc. I do say there's quite a good analogy between the retail impact guidance, which on its face, following steps should be taken, checklist, and 7028, which on its face is saying this is what you should do in considering reasonably available. But Mrs. Justice Lieven's point is you have to read that on its face mandatory language in the context of the intended function and status of the PPG. And doing that leads one to the conclusion that actually the excessive legalism is not on this side of the court, it's the other side. It's the inspector who treated the PPG excessively legalistic, just as Mr. Neal for the claimant and solo retail treated it. I hope that's
Yep.
a clear statement of my position in relation to this case. Let me just check my notes and see if I need to say anything more about solo. Don't think I do.
All right.
Um,
And then
Unless-
the two judgments of Mrs. Justice Lang.
Yes, so White, Waltham, Airfield is the chronologically first, and that's at tab 14.
Found the page, sorry.
Again,
Can you go to page
Page
number?
number.
sorry, forgive me, I do apologise. Page 293 is the first page of the judgment. The
293.
first passage I want to refer to is at 294.
Yep.
And again, just by way of context, this is another case where there was a framework requirement for a kind of assessment, in this case a noise assessment, and PPG guidance on how that assessment should be done. And the overall finding was the PPG did not set out a binding exhaustive pathway for compliance with the open textured policy. So again, I say analytically similar at least, and on all fours at best, both with Solo and with the present case. By way of background, you've seen in paragraphs 1 to 3, it was a planning permission for a housing development adjacent to an airfield. The airfield brought the judicial review. Its concern was that the housing development might sterilise it because of potential nuisance claims, etc., sterilise the operation of the airfield.
Yeah.
At paragraph 6, the relevant ground was ground 2, that the contrary to the PPG, there had been a failure to recognise by the council that the noise assessment hadn't done what it should have done. In particular, the complaint was, and you see at paragraph 9, the factual background, that the airfield wasn't currently at that time being used to its full permitted extent, and the complaint was the noise assessment, i.e. was the noise from the airfield intolerable to the occupants, such as to create a potential future nuisance claim, only looked at the current levels of use as opposed to the potential full permitted extent of the use. That was, in essence, the complaint in that case. And I asked the court to go to paragraph 34 on page 303 of the bundle, where you see the key policies. I should probably take you to 33.2, paragraph 180 of the then framework. Sets out an overall requirement development is appropriate for its location, taking into account likely effects on various things, including living conditions, the requirement to mitigate and reduce to a minimum noise impacts and avoid significant adverse noise impacts. In broad terms. 182, policies and decisions to ensure new development can be integrated effectively with existing businesses. Where the operation of existing business or community facilities, there's 5 lines at the bottom, could have a significant adverse effect on new development, then the applicant should be required to provide suitable mitigation before the development has been completed. So those are the general broad text, similarly to reasonably available, broad textured framework requirements.
Yeah.
And then you see the PPG, which is introduced at paragraph 36, the judgment, guidance as to how noise impact is to be assessed. And then the critical passage of the PPG is at 44. And the PPG says, and this is the last 3 lines of 44, the developer or agent change will need to take account both of current facilities and those activities that the businesses are permitted to carry out even if they're not occurring. So that was the crux, foundation of the complaint in that judicial review. Then you can go forward to, because there were other grounds in play too, you can go forward quite a long way in the judgment to page 314, D14, where the analysis on ground 2 is set out.
Yeah.
And you see there the complaint, which I foreshadowed at 69 and 70, that the approach in only assessing the current activities was contrary to paragraph 182 of the framework, and in particular the PPG. And sees then 77, after having said, well, obviously the decision maker would have been aware of the NPPF and PPG. 77, the claimant submits, the council failed to have regard to the passage in the PPG, which states you need to take account of permitted activities as well as current activities. The claimant is seeking to elevate the PPG into a binding code which strictly prescribes the steps that a local planning authority must follow when undertaking its assessment. That's a mistaken approach. It's merely practice guidance which is intended to support policies in the framework, as Mr. Justice Stevens said in Solo Retail, ... Now, again, my reliance on this passage ought to be fairly obvious, but I make 2 points in particular. One, read across the Solo Retail, buttressing my argument based on Solo Retail itself that paragraph 33 of that judgment was not fact-specific, but a statement of principle.
You say that reinforces that understanding.
Yes. And further, I endorse what's said at paragraph 78. I ask this court to adopt it. You don't have to, obviously, it's not binding on you, but I say it's right for the reasons I've largely set out already in terms of the proper understanding of where the PPG sits. It's not a rival corpus of policy. It sits underneath the framework, is intended to sit underneath, and always was C. Taylor, etc.
Maybe the question is, can the PPG support the NPPF legitimately by explaining concepts contained in it, not defined in it?
Yeah, that may be the one way of looking at it, my lord, and I say no, because that's not to support, that's to rewrite.
So PPG cannot, again, sorry, forgive me, it can't support, and I'm using that word advisedly.
You can't support the implementation of policy, which is the word used in the opening part of the Taylor Review. You can't support the implementation of national policy by changing the requirements of national policy. That is to do a different thing.
But can it do it by explaining something in national policy?
Only if that explanation is to provide non-exhaustive focus, which is not how the inspector and the judge treated 7028, but is how Mrs. Justice Leven treated the retail PPG.
But you've accepted already that the PPG here didn't properly understood exceed its proper role.
Well, yes, but for the same reason.
Yeah, but
yes.
But it's not committing any of these sins, if you like.
Once it's properly understood.
Once it's properly understood.
Which means not taking a semantic, overly legalistic approach and treating it as mandatory, even though it uses language that has a flavour of obligation, for the same reasons that Mr. Justice Leven analysed the retail checklist you should in solo retail.
And so far as it may matter, can I just understand the documents with which Mrs. Justice Lang was concerned? So 44 in the PPG, we see
I've just lost my lord, I'm so sorry, 44.
Sorry, paragraph 44, where there's a reference to the PPG.
Sorry.
That's focusing on activities that businesses are permitted to carry out even if they're not occurring at the time. So that's the PPG.
Yes.
And that's to be compared with paragraphs 180 and 182, is it, of the NPPF, as quoted in paragraphs 33 and 34. And 180 simply stated in general terms that they should mitigate and reduce to minimum potential adverse impacts.
Yes.
Which could be either existing or for the future, presumably. 182, as the judge says, the focus is on pre-existing.
Well, it's not existing business, not existing operations.
Yes.
So actually, there's quite a good comparison, because this. We remember the discussion we had a little earlier about the fact that the Menston case was a more obvious tension.
Yes.
Here, it's much closer. You've got a broad, open textured framework policy.
Yes, I see.
One rational application of which was the approach the council took. PPG then saying within that, no obvious ostensible clash, but saying you've got to have regard to the headroom, the stuff that isn't happening but could happening. Claimant saying you haven't done that, and you should have done. And the judge saying, well, you didn't need to under the framework. Yeah. And again, on the Holgate approach, on the inspector's approach, and on my learned friend's approach, if they're right about 7028, it's quite hard to see how this case was properly decided. Because on their approach, there would be a requirement to have regard to existing businesses. On its face, it's expressed in, I say inverted commas, mandatory language. But once properly understood, having regard to where the PPG stands in the hierarchy of promulgation from government, it doesn't do that. That's why I say, to be very clear, that is why I say the inspector misunderstood the PPG. Because he didn't have a proper understanding of where it stood in that hierarchy.
Yeah.
Even though the wording had a flavour of obligation. just want to check if I need to say anything more about... Well, the only thing I want to say briefly is draw attention over the page to the reference to Bent, which I am going to come to. Because Mrs. Justice Lang saw the solo retail as being preferable to Bent. Actually, Bent doesn't really determine this issue, it's on a different point, as I'll show you, but to the extent there is a tension, I endorse what Mrs. Justice Lang said. And clearly, what I say to be clear is that in the present case, the inspector elevated the PPG to precisely the same kind of binding code as to how to undertake an assessment as Mrs. Justice Lang held was illegitimate in that case. No coherent or principled basis for taking a different approach in relation to a flood risk assessment than there is in relation to a noise assessment or a retail impact assessment. Can I briefly, I'm conscious of time myself, if you don't mind, can I take you to Bent briefly, if only to show it's a red herring. And that's at tab 9 of the authorities. And can I ask you to have a look at the headnote first up, because this is of some significance into putting the case into context. But Bent...
Sorry, page?
Page 202.
Thank you.
Bent predated Solo Retail and White Waltham. And you will see at the headnote, Menston was not cited to the Deputy Judge. Now, there's probably a good reason for that, and the reason can be seen when we go to paragraph 37 on page 215, which is that this case wasn't about what the PPG could do, but about the interpretation of the PPG, or the relevant passage was. So the passage that Mrs. Justice Lang saw as being in conflict with Mrs. Justice Leaven's judgment, which I'm not convinced there is a conflict, though to the extent there is, I ask you to prefer Mrs. Justice Leaven. The passage is 37 on page 215, the bundle, page 83 of the law report at letter C. And that, having cited the approach to the interpretation of the MPPF, says, broadly speaking, the same as to apply to the PPG, and then it's the passage which comprises a mixture of policy and guidance produced in a less formal manner. Now, to the extent that policy means it's the same as the framework, I take issue with that language, but it wasn't before the Deputy Judge to decide whether it was or wasn't policy. The point there was, how do you interpret it? There was a challenge to, based, if you look a little bit early on the judgment, the 33 and 35, one of the arguments was a failure to have regard to and properly apply the PPG, but not as a tool for compliance or otherwise with the framework. The relationship point wasn't an issue. The point that Mr. Elvin was making was simply that as part of his rejection of that claim, that the freestanding claim based on the PPG as opposed to a relationship point, the claimants were being overly legalistic as the interpretation of PPG. So it doesn't, in my submission, help the court on the issues that you're asked to decide. And the fact that the argument was put that way probably explains why Menston wasn't cited. So unless I need to, I won't say any more about Bent. But the judge below thought Bent was helpful. I dispute that for the reasons I've given. We're the penultimate stop on our journey through the case law. I hope it's not been too slow. The end is in sight, and we're now at Bramley, the second Mrs. Justice Lang judgment. That is at tab 15 of the bundle, the last, tab page 319.
Thank you. And it was a challenge to a, the judgment actually starts at 325, a lengthy head note. You see at paragraph 1, it was a 288 statutory review
to a inspector's decision to grant permission for a solar farm, essentially at a place called Bramley in Hampshire. There were many grounds of challenge, summarised at page 326, paragraph 4, and the relevant one for present purposes is 7. The lack of alternative, failure to have regard to the material consideration, lack of alternative sites. Because it's ground 7, we can go straight through to page 352. Law report page 609, which is where that ground is considered. And the judge starts by going through the case law on, generally speaking, where alternatives may or may not be relevant to planning. Don't need to consider that thorny chestnut, thankfully, in this case.
No.
But at 164, there's reference to PPG, where the claimants considered there was a PPG hook for an alternatives argument.
Yeah.
And you will see at 164 the quotation of the relevant paragraph. I just draw attention to provide context to the later arguments, particular factors, 4 lines down, a local planning authority will need to consider. Again, on the face of it, the flavour of obligation. And then the bullets, encouraging effective use of land by focusing large-scale solar farms on previously developed and non-agricultural land, provided it's not of high agricultural value, where the proposal involves greenfield land, whether the proposed use of any agricultural land has been shown to be necessary, and poorer quality land has been used in preference to higher quality, and so on. So that's the context. Then at 165, there is reference to both Solo Retail and White Waltham, which I just note, foreshadow, the judge purported to apply at 177. So again, rather suggesting they're not confined to their facts, but there's a theme emerging in the case law. See end of 177. You then can see at...
Well, the theme is not binding effect, isn't it?
Yes, theme is not binding, even if the language has a flavour of obligation about it. They're not a binding criteria for purposes of assessing compliance with the governing paragraph of the framework.
Yeah. I'm sorry if I'm asking a question that one way or another you've already answered many times. Perhaps you have. Forgive me. We've heard a lot about binding effects, straitjackets, and so on. If there is a concept in national planning policy in the NPPF, which goes for one reason or another, goes undefined in the NPPF, a concept. Is it the legitimate role of PPG, or can it be, to provide that definition? In other words, to explain what the concept means.
You can explain what it normally means. See substantial harm, the heritage example I gave earlier. So I do, with great respect, say, so if I haven't answered that specific question, my answer is the same as I gave in that earlier concept, where if you remember it said in general terms, for example, considerations, and that's what I mean by giving a steer or a focus.
To be clear, it can explain what it normally means, but not what it
always means.
Not what it does mean?
Yes, or always means, or must mean. So it can, yes. Because
not going to
once
provide much useful guidance if that's all it does.
Well, with respect, I disagree, my lady, because providing a steer can be helpful to users of the planning system for the reasons that Lord Taylor refers to in his report. He refers to guidance can add real value in terms of practice, contains important how-to material, just as the retail impact did. It can provide a steer of how you ordinarily go about things. What it cannot do is change the parameters set by the national policy. And that would be far less helpful for the reasons I gave, because that would make it the job of those using the planning system much harder, because they would have reams and reams of PPG to wade through to understand what the policy requirements were.
Yeah, but if the national policy does not set parameters, there are no parameters there to be changed. We're in the business here of considering, I think, aren't we, the lack of a definition in the NPPF, which is effectively supplied in the PPG.
There are always parameters, but the parameters, if they're not set in terms, are public law parameters. So reasonably available, as Lord Justice Holgate said in the judgment below, is an open, broad textured policy that emits a wide range of consideration. Those are the parameters. They're deliberately broad. That's a policy choice. That's part of the process of consultation, of lawyering, of coordination with other policies. All of that is a deliberate choice. If they'd wanted to define it, they could have done. There is a glossary that has a whole range of definitions on a whole range of different things. That is a choice. That is the fruits of that consultation. And if government wants to set narrow parameters, it has a way of doing so. It's not the PPG.
So sorry, I got
No.
I just wanted to ask that question.
And I'm not sure this is a very useful one, but you sort of suggest, well, your case reduces the burden on developers. But does it really? They've still got to look through the PPG.
Yes, but knowing what they're looking for, which is they're looking for guidance, not policy. Because the approach against me, so I understand it, as put by Mr. Flanagan, he doesn't say that those cases I've just taken you through were wrongly decided, as they confined to their facts. So sometimes the PPG is only elucidating in the way I describe it, providing non-binding guidance. Other times it's redefining. Well, how on earth is a planning consultant, a landowner, a developer meant to work out which of the two it is without, great for me, because council's opinion will be needed every single time in order to understand, is this particular piece of the PPG providing policy, or is it providing guidance? Is it defining? Is it elucidating? Which is it? That is overcomplication. Treating the policy framework, the primary document, which is consulted upon, etc., as setting out the policy, and the guidance as guidance, and no more than that, on how that policy should be implemented, is clear, simple, user-friendly, in my submission. I forgot where I was now. Sorry.
Well, you were at 177.
I was, wasn't I? And can I just... yes, so at 171, I think, page 355 of the authorities bundle, this is now the claimant submission. So they were saying that the inspector's reason was flawed because the PPG imposed a duty to consider alternatives. There may not have been a general common law duty, but the PPG made a difference, was in essence the approach taken at 171. And then at 177, you see, and this case is less directly on all fours with the present than the others because it's not a relationship case, it's a PPG. It seems, anyway, on the face of it, to be a PPG standalone case. So I fully accept that. But what we do see at 177 is the reiteration that it's merely practice guidance, supporting the policy and framework, so a clear restatement of that hierarchy, not a binding code that presides the steps must be taken, which I've already made my submissions on, and solo, retail, and Whitewath and read across this context too, which supports my approach of general principles as opposed to my learned friend, the judge's approach of fact-specific. Now, unless you've got any questions, there's Braintree, and then we're through the talk of the cases. Right. Braintree is at tab 11, page 242.
Thank you.
And see at the head note, the issue was the interpretation of what was then paragraph 55 of the framework, which was a provision that authorities should avoid new isolated homes in the countryside unless there are special circumstances. And the question was what meant by, in particular, isolated and the word settlement in that context. Then one goes to, and for context, we probably need to start at around 31 on page 252. We're having looked at dictionary definitions and Latin, which prompted my delving into dictionaries and Latin yesterday. Classics degrees Mr. Flanagan and I both have, can still be useful. And then 31, my Lord held that paragraph 55 is isolated as a matter of fact and degree judgment for the decision maker, as to which I say so too is reasonably available. Classic statement of approach to planning judgment in the application of an open-textured, broad policy. Then my Lord goes on at 33 to say, well, does your reading fit both in the context of the framework more broadly and the PPG? And you found that it did. And partly for that reason, the discussion in the paragraph at 36 on the PPG was obiter, as you yourself recognised.
Yeah.
A note.
That's 36, isn't it?
36.
Yeah.
Mr. Whale, note that the third line, Mr. Whale was counsel for the Secretary of State.
Yes.
And the Secretary of State suggested that the use of the PPG to assist in construing policies in the framework would be inappropriate in principle. Now, just noted by yes, exactly.
What's it there for?
And I mean, it's. I don't want to take a jewellery point, but it's interesting that the Secretary of State's last known statement on the function of the PPG prior to him issuing 7028 was that. It seems now that, he's obviously saying that when he issued 7028, he in fact intended to and did do something other than what he was telling the Court of Appeal not that long beforehand. And you said, go on, say it's not something you have to decide. You doubt it'd be right to exclude the guidance of the PPG as a possible aid to understanding. This is not such a case. Now, I've given quite a lot of thought to this passage, and it's not quite the same thing. There's maybe an overlap in the sort of Venn diagram concept. Whether it can be an aid to interpretation, whether PPG can define or rewrite.
Two different situations potentially, aren't there? One is where you've got some genuine ambiguity about what the NPPF policy means, and there may be indications to be found in the PPG on the one hand. On the other hand, where you've got a crisply referred to concept in the NPPF, which goes without definition in the NPPF, but which the PPG very deliberately and explicitly sets about, supply the verb, explaining, elucidating, defining, whatever you want. Those are qualitatively two different situations.
I agree. And obviously the present case is not concerned with
I suspect Braintree was in the former category.
Yes, and to put it, and I don't need to go as far as saying that the possibility you didn't exclude would be impossible. Clearly, the closer the nexus in time, the more likely it may be. So take, for example, a current illustration. So the new NPPF, there's a consultation on introducing a category called grey belt. So a new category of appropriate development in the green belt. Yeah. And some of the language used in the relevant paragraphs is fairly broad. So, for example, one of the glossary has a definition, interestingly, and the proposed definition talks about limited contribution to green belt purposes. Yes. Not ostensibly clear what that means to all of the green belt purposes or to some or others, etc.
Yeah.
Now, were there to be PPG issued on the same day as the new framework, the final version is published,
Yeah.
which provides colour on that phrase, one could see how it may be legitimate to see, well, that's what it may or may not, but you can see how potentially there may be the situation my Lord potentially had in mind, that the contemporaneous publishing of guidance may show what. I don't like to analogize with an explanatory note because then I'll be told I'm interpreting policy like a statute, but there may perhaps be a degree of read across there. But here, 708 was a decade afterwards.
Yeah.
So it's quite a stretch to say that 10 years later, something that went up on a website without consultation, without lawyering, etc., is illuminative as to what was had in mind. Yeah. And the policy was originally, in fact, it's more than 10 years because it was in the PPS as well.
Yes, all of that may be right, but the government put it there, and maybe it had only got round to it rather late, but it did put it there, and it's clearly, on any view, it's clearly directly related to that policy in the NPPF as it stood.
But the question
then continued to stand, actually.
Then they put it there, but to what end? And
Well,
that's
what the case. That's what this case is about.
Probably the key point you have to decide.
Yes.
And I'll be repeating myself if I answer that question because you know.
No, well, that's fine. Understood.
I think that's all I need to say. I mean, the last thing, for what it's worth, and probably not very much, but what it's worth, when my Lord says at 33, the policies for sustainable development in the framework and guidance in the PPG, whether inadvertently or deliberately, I say that does properly characterise the distinction between the two documents. I mean, I only say that because I've got the case before you, but I say amen to that. And that is a better and more accurate description than Mr. Elvin's in the Bent case, but obviously it's not a finding. I just say that because we're with the judgment. So then moving forward, I'm conscious of the time, I don't want to overstay my welcome, but in terms of the principles, I largely covered those already.
Right, let's just take stock then. We've now finished 3, and you're going...
I was going to just briefly pull together up the principles, say something then
where the inspector went wrong.
Yes, that's going to be a paragraph, because really, by that stage, you'll...
I suspect you've done that, haven't you?
I think I probably have. Can I say a few things on principles? Yeah. And then I suspect where the inspector went wrong, where the judge went wrong, will be sort of self-explanatory by that stage. I have those sections in just in case there's any sweep up to do, but it may very well be I could just say see above.
Yes, okay.
So the principles to be derived from the case law, again, we don't need to go there, but the flags for our skeleton will be paragraphs 25 to 27 and 39 to 40. And as I said, although the cases are binding, I say they're right, firstly. Secondly, they've arisen in a range of contexts and yet have generated a consistent analysis across those contexts. Thirdly, they reflect what was until the judgment below a consensus amongst some of the, if not the most experienced judges of the planning court, Mr. Justice Dove, Mrs. Justice Leaven and Mrs. Justice Lang. And fourthly, they reflect the position as of when PPG 728 was issued. So I say all of those things are things I ask the court to bear in mind. So putting all that together, what I say, and this is broadly reflected, not quite stated in the way I had invited him to state it, but broadly consistent with paragraph 46, the judgment below. Firstly, the PPG is subservient to the framework. It cannot override the meaning of the framework. Menston.
Right, you say paragraph 47, but though?
46.
46. So Menston, yes.
So subservient cannot override the meaning. Secondly, it cannot and should not be interpreted as setting out mandatory requirements as to the application of tests set out in the framework. See Solo, Retail and Whitewater. It can provide a steer in the way that I've described, but not mandatory requirements, for the failure of which will lead to conflict with the policy. Thirdly, where the PPG corresponds to a passage in the framework, and I use that word because that's the word my lord used in Braintree. The paradigm being where two are published simultaneously. Where it corresponds to a passage in the framework, the paradigm being where published simultaneously. It might illustrate the purpose behind that passage, and as such one cannot exclude its potential to be an aid to interpretation. Braintree. Fourthly, considerable caution must be applied in that context for the reasons given by Mrs. Justice Leven in Solo Retail. And fifthly, the PPG cannot, on any view, alter the meaning of pre-existing MPPF policy, which would infringe the first two principles, either or both. That would stretch any concept of an aid to interpretation beyond breaking point. That would be rewriting, not interpreting. Then some further observations that follow. I'll just let you finish your note, sorry.
That's right. Sorry, carry on.
So at 28 and 32 of our skeleton, we deal with the source of power. I largely foreshadow this submission, but let me just be clear, just in case. The centre of the judge's analysis was the point that the source of power to promulgate the PPG is the same as the framework that identified by the Supreme Court in the Hopkins case, an applied power in the statutory code. I say in response to that, the source of the power doesn't tell one how the exercise of that power is to be interpreted in the Tesco and Dundee sense. So it's not really asking the right question. Here, the function and effect of the PPG, properly interpreted in Tesco and Dundee principles, is, as I've explained, its function is to support, sit beneath the framework in the sense described by the Taylor Review and by the cases, particularly Mrs. Justice Langham, Mr. Justice Dove, and Mrs. Justice Leven, offering practice guidance, no more than that, guidance. That is what elucidation means in this context, properly understood, on the application of policies in the framework. And put differently, at the risk of repeating myself, and if I am, I'm sorry, whilst the source of the power is the same as the framework, in the case of the PPG, the Secretary of State has exercised that power to great guidance which is subservient to the framework in the sense set out in the cases I've shown you. Not, this is critical, not a rival corpus of policy which can amend and redefine the framework. That, I say, is evident from how the PPG is packaged and presented to the development industry. That's how it's held out. See, in particular, its title, its format, and the different process by which it's issued, all of which are indicative of it being held out to perform a different role to the framework, to sit beneath, by guidance and not be interpreted. It's not a rival corpus of policy. It's not held out as defining the interpretation of national policy. You don't nowhere will you find a statement in it or in the Taylor Review saying that's what its function is. And indeed, the Secretary of State's last known public statement on its role, prior to this case, was in Braintree, where he said it couldn't even be a guide to interpretation. My learned friend, at paragraph 28 of his skeleton, he concedes that in his language, the PPG sits underneath the framework. And he then says that's a policy rather than a legal distinction. We'll hear what he means by that, but I, with great respect to him, I suggest on its face that's an unhelpful elision. The fact that it's the Secretary of State's policy in the general sense for the PPG to sit underneath the MPPF and be subservient to it is a legal distinction, because it provides the answer to whether the PPG should be construed on Tesco and Dundee principles as being a rival corpus of policy as opposed to guidance on non-binding guidance on the application of the framework. Then, in the same context, I'd like to meet what my learned friend says at paragraph 29 of his skeleton, reflecting the judgment below at paragraphs 113 to 115. So 29 of the respondent skeleton, 113 to 115 the judgment. My learned friend and Mr. Justice Holgate, who then was, place considerable emphasis on the public law principle that a policy can never be binding. It can't be a fetter of discretion. And he saw that as meeting our point that the PPG can't be treated as a binding code, i.e. policy never can. So what? What's your point? It's essentially the argument against me. But in my submission, respectfully, that confuses two separate concepts. One, binding in legal terms as a fetter on discretion. And two, binding for the purposes of ascertaining whether a development is in compliance or in conflict with the framework. Now, clearly, no statement of policy, whether it's PPG, a written ministerial statement, or the framework, can be binding in legal terms because there was always a public law discretion to depart, even a development plan. That misses the point. Whether or not a proposed development, or indeed a plan, is in accordance with the MPPF, or is put forward as a departure from the MPPF, that itself has important, indeed often fundamental, often determinative, as in this case, consequences for decision making. And how the inspector treated the PPG was to impose binding, in the literal sense of that word, criteria which had to be satisfied if a development was to be in accordance with paragraph 162. Not a nudge, but a straitjacket. That's where in my submission he went wrong. And I think by those words I've also not just completed section 3, but completed section 4 of my submission.
Yes, and possibly also, just conceivably also, section 5.
I think that's probably right. I've got a miscellany of points in my notes. Can I just spend a moment checking whether I've covered them all?
Point 5 was where the judge went
yes,
wrong, but you've woven into your submissions on the inspector going wrong, submissions on the judge going wrong.
The only sort of point of the miscellany that I haven't foreshadowed already is paragraph 100 and 107. So can I just take you to that? I think everything else I would be repeating what I've already said, so I won't do that because I won't be thanked for it. So back in the judgment.
Yeah.
Makes the point at 100 and goes back to it at 107. And if I can introduce the point and give my response to it. So at 100, he says there's nothing in the language of the MPPF, and by that he means 162, which could justify the court adopting the highly specific interpretation contended by us, namely, and then essentially CS3. And he goes back at 107 to call my approach highly prescriptive. And with highly prescriptive interpretation, with great respect, that's quite an important mischaracterization of our case. We did not, and do not, and nor do we need to, say that CS3 was the only rational application of paragraph 162. If it was, and every policy in the country, every development plan policy on flood risk would look like it, and they don't. It was within the previous broad range of rational applications of the framework. Mr. Justice Holgate himself accepting that that paragraph was broad, textured, etc., elsewhere in the judgment. What the PPG did was take it out of that range So I'm not arguing for, it's a mischaracterisation of my case with great respect to the judge. I'm not suggesting anything that's overly prescriptive. Actually, quite the contrary. I'm relying on the breadth of 162 and complaining about that breadth having been narrowed illegitimately in the way that I've described. I think if I said any more, I'd be going over old ground. So unless I can assist you any further or answer any questions, those are my submissions for now.
Thank you very much.
Thank you very much.
Thank you. Yes, Mr. Flanagan.
Please, Your Lord, I'm going to first deal with ground one, put in the grounds of appeal as whether the judge was wrong to hold that the PPG could amend the framework, and then turn to ground two, which relates more to the decision letter in this case. The first three overarching points, I make clear that it is right that the department takes the view that the PPG is intended to support and complement the framework. That's the intention.
Intended to support and
Complement.
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 Sorry, I missed that. Yep.
Secondly, looking at the present case, in the paragraph of the PPG in question, I say that the 7028 is in accordance with that role and intention. It is elucidating what is a broad and open textured policy in the framework, paragraph 162. And just still on that second point very briefly, so this is a fairly clear example of that, because looking at the terms of paragraph 728, which is page 29 of the supplemental bundle, I've been to already.
Yeah.
7028 is all under the heading of what is a open quotes reasonably available close quote site. So it is taking the precise words of the framework and seeking to explain them. It is staying faithful to the words of the framework and not, in terms, it is not changing them. It is pure explanation, elucidation. So that's the second overarching point. The third overarching point is that I also say that as a matter of law, Mr. Justice Holgate's analysis is correct in that, in theory, there is in fact no legal restriction which would prevent the Secretary of State from going further and using the PPG to actually amend the framework. That is a theoretical question only, because I say it's not what PPG is purporting to do in this case, but legally, no restriction on doing that. And the judge's example of actually amending the framework or positively altering it may be a slightly stark one, I accept, but it's important, as I state in my submission, to recognise that that is the legal, the correct legal position, because if that is right, then what this bit of guidance is doing, which is defining elucidation, must be a fortiori possible and legally permissible.
Yes.
So just expanding on those three overarching points. As to a few submissions on the legal status of the the framework and the PPG respectively.
Yeah.
Obviously, the bench will be entirely familiar with the fact that government policy comes in many forms. Planning is no exception. The framework, written ministerial statements, the West Berkshire case, for instance, and the PPG, I say, is still in that general category of policy, even though it's less formal and badged as guidance. And you also, of course, have statutory policy such as development plans and national policy statements in the infrastructure context. But given that dealing with the non-statutory policies, given that the NPPF, the PPG, written ministerial statements, none of those have any statutory basis, there is no legal basis, I say, to distinguish between them, to treat them as legally distinct, as the judge put it. And nor is there any basis to put them in some kind of legal hierarchy, which, as I say, is the effect of my learned friend's submissions. And I say that is supported by two of the leading cases in the planning world. I could just briefly go to those. The first is Alconbury. The senior president will be very familiar with the case.
It's a long time ago. But yes, that doesn't mean you have to spend more time taking me through it.
I certainly won't do that. So the case raised fundamental questions about the compatibility of the planning regime with Article 6, which is not the point I go to it for. But within that major question, there was discussion about the role of and the nature of policy, and it's particularly clear in the speech of Lord Clyde.
Yeah.
So it's Authorities Bundle, page 60.
Yeah.
Lord Clyde's speech starts at paragraph 137, and the particular passages I rely on, under the subheading of the planning context, we've got paragraph 139, and then it's particularly paragraph 140. I could just invite the court to read the first half of paragraph 140.
Yeah.
And the Lord Clyde's reference in between D and E to national planning guidance being prepared and promulgated, I say, in this context of discussing the role of the Secretary of State, is not distinguishing between the precise name or form of advice proffered by the Secretary of State, whether it's policy or guidance. It's fulfilling that role of being national planning guidance. The NPPF and PPG both fulfill that same role. And the other reference is it over the page, paragraph 143. And again, if I could just ask the court to read the first half of 143. And the particular sentence I rely on is 4 lines in. The formulation of policies is a perfectly proper course for the provision of guidance in the exercise of an administrative discretion. So again, treating policy and guidance as essentially the same thing. And the phrase that guidance is policy is guidance in the exercise of an administrative discretion, I would say, can't be improved on in terms of the nature and role of policy, and the PPG and the NPPF are both filling that role. So that's Alconbury. The other case is Hopkins Developments, in the Supreme Court starts at page 174. Hopkins claimant.
Yeah, there is another case called Hopkins Development.
And this Hopkins Holmes, again, of fairly seminal importance, dealing with issues in terms of planning policy. And page 185 in the Justice Lord Carnworth, under the heading, top of the page, NPPF legal status and interpretation. So this is useful again because it is addressing head-on the nature of the legal status of the NPPF. And if I could ask the court to reread paragraph 19 of Lord Carnworth's judgment.
Yeah, which refers back to Holkenbury.
It does. And in the second line, Lord Carnworth, again, talking about national policy guidance. So eliding in a single phrase both policy and guidance, rather than drawing a sharp legal distinction between them, which is the effect of the learned friend's case. That's the first point from paragraph 19. The second point is as to the source of the power to issue both policy and guidance. And there was a controversy about this, which Lord Carnworth resolves in favour of it being implicit in the statutory framework. But the relevant point in my submission is that, indeed, I think it's learned friend accepted, that the source of the power to issue both is the same, again, implying no legal distinction between them. So, in light of those that case law and discussion, I say, regardless of how you badge them, policy and guidance are performing the same function. Their provision of guidance in the exercise of an administrative discretion. And it is, in legal terms, in my submission, excessively legalistic and forensic to try and draw a sharp legal distinction between them, to pigeonhole them, as I said the appellant's doing. What I say about the legal position, in terms of precisely how that power has been exercised, so I accept the PPG has been exercised, published to be a supporting suite of guidance, supporting the primary document, which is the framework. But I also say that it's not an entirely uniform picture. So it does depend on the nature of the policy in the framework, as the judge held below. So in some cases, and he gave the example of Greenbelt policy is quite specific in the framework and prescriptive. And that leaves less room for guidance and explanation to be provided in the PPG. Whereas in the present case, the policy in the framework is high level, broad, open textured, and that leaves significantly more room for guidance to elucidate, explain, elaborate, etc. Consistent with what 7028 is doing. So I say that the precise division of labour essentially between the two documents, the NPPF and the PPG, will vary on a case by case. Another reason not to draw a sharp legal distinction between the two, because they may in different cases form slightly different roles. I was then going to turn to the cases relied on by my learned friend,
Is this under the same heading?
This is still all under ground. Yes, it is still under the legal status of the framework and the PPG, and all under ground 1 still. Okay. And so, by way of introductory remarks on the cases, see, a number of first instance cases are relied on by the learned friend, where judges clearly have commented to some extent on the role and status of the PPG. I do say that they are all concerned with identifying and giving effect to the role, the intended role of the PPG in each case. In other words, they are exercises in interpretation of the PPG in issue. What they are not, and they do not purport to address the separate question of the legal status of the framework and the PPG respectively. None of them engage at all in the legal analysis that was conducted below by Mr. Justice Holgate in terms of whether there's any sharp legal distinction between the two. None of them address in principle question of whether the PPG could seek to qualify, amend, alter, or do something of that sort in legal terms, or lawfully. And so I say they don't assist with the question posed in ground 1, which is whether the judge was right to hold that, in principle at least, the PPG could qualify or amend the framework. That's the introduction. In terms of the cases in question, my learned friend has taken them in some detail, so I'll be economical. Could I first go back briefly to solo retail?
Yeah.
And the relevant paragraphs.
You should give us page numbers, though.
Excuse me. It is, starts at page 279.
Yep.
And paragraphs of particular interest are at page 291, paragraphs 33 and 34. And could I just take them in reverse order, as I said, because it's important in my submission to have regard to the PPG being looked at in question. So 34, the judge refers to the PPG that she's there considering, and 4 lines in says, taken at face value, these words would seem to suggest the following elements are mandatory, where there is a policy requirement for any form of impact test. However, in my view, that cannot be the case. And then she goes on to explain why. In essence, that is an exercise in interpretation and finding that the PPG there was not seeking to impose some additional test beyond that found in the framework. It doesn't go any further to deal with the legal question of the relative role of the respective role of the framework and the PPG, and whether there's a, say, sharp legal distinction between the two. That's paragraph 34. 33, obviously the judge in 33 does deal with matters slightly more broadly. The second half of 33 in particular, 4 lines from the end, 33, the judge says it's intended, that's the PPG, as its name suggests, to be guidance, not policy, and must therefore be considered by the courts in that light. So the judge drawing a distinction certainly a distinction between guidance and policy, but that, as I say, is a policy distinction, as in it's a policy choice by the Secretary of State to have a primary document, the framework, and to have a supporting document guidance, it's not a legal distinction the judge is there referring to in my submission. And it would be quite open to the Secretary of State to use the PPG to go beyond simply supporting the framework. It could, no reason why legally, why the Secretary of State couldn't use the PPG to go further and add something, or indeed qualify something.
So in your case, the judge's remarks in paragraph 33 are, so to speak, going to the way in which one should set about the process of interpretation.
Yes, that when interpreting the words of the PPG, one should do so fairly and in context, that the PPG purports to be a supporting document, and it would be wrong to ignore that context. That's all that I'd say is essentially being said there.
You said not prevent the Secretary of State going further to do two things, and I didn't note those.
I suggested that to add to or qualify.
The NPPF.
Yeah. And I say that because Mr. Justice Holgate went further and actually talked about amending the framework by the PPG, which, as it is, I say, quite a stark example, and it's not obvious to think of an example where that might happen.
Well, you submit, do you, that that isn't this case, that this case is about providing an explanation or even a definition of the concept of reasonably available sites. Indeed, that's the question posed in the title to the paragraph we're looking at.
I do.
That was merely explaining what the government meant, or now believed it meant, in using the undefined concept of reasonably available sites in the NPPF.
Precisely so. And on that theme, a learned friend, the court has observed that the framework has itself a glossary of definitions, which contains definitions, and so it said, well, if definitions were to be provided, shouldn't they perhaps be in the glossary? And the glossary does contain definitions, but there's nothing to prevent the Secretary of State providing a definition in part or whole through the PPG rather than necessarily through the glossary. And looking at the nature of the definition that you get in paragraph 728, it's quite a loose definition. It defines by giving examples. A series of sites, for instance, is said to be potentially within the scope of the framework's language. So I say it's entirely understandable why that sort of explanation or definition you might find in a supporting document rather than in the primary document.
Can we just look at those words again? Page 29.
Yes.
Starts by telling us what decision makers, this is under reasonably available sites are those in a suitable location for the type of development. Reasonable prospect the site is available. So you've got two, as it were, exercises of evaluative judgment there, have you?
Yes.
Suitability and availability on a timeline. So those are matters of planning judgment, are they?
Yes.
And then could include, one might be tempted to ask, is that the language of a straitjacket?
No, it's clearly a non-exhaustive definition.
Could include a series of smaller sites and or part of a larger site. So you've got the option and or. In other words, sorry, it's not. It's three options actually. It's and or it's the alternative.
Three possibilities.
Or a mixture of the two, as I read it.
Yes.
If these would be capable of accommodating the proposed development. Another value judgment. such lower risk sites do not need to be owned. That admits of the possibility that they might be owned. Don't have to be considered reasonably available. 5-year land supply not a relevant consideration. So when we think about the whole concept of imposing a straitjacket as opposed to something less, what do you say about the actual language as we now look at it in the guidance?
Yes, I say it's certainly not the language of straitjacketing, as it was put. It's loose. There are some bits which are firmer, but a lot of it is to use the term the judge used, open textured. The judge used that term about the policy, the framework, but the same is true almost of the explanation in the guidance.
Well, you submit, do you, that it's not as open textured?
No, it's clearly adding flesh to the sort of high-level concept of reasonably available, but the way in which it does so isn't particularly prescriptive.
Well, that leaves us the question, or begs the question even. Did, however, the inspector read it as if it were binding? In other words, you've got the language there, but did the inspector go wrong in taking it as if it was a straitjacket?
Yes.
That you do have to confront.
Yeah, so that I accept is a separate question which also needs to be addressed.
Is that really underground too?
That's how I put it. Yeah.
I mean, that's I put to Mr. Lord Banner earlier on the question whether that was actually ultimately the crucial question in the case.
In my submission, yes, and indeed, I hope it's fair to say I think it was the focus of the submissions you heard this morning about whether the inspector misunderstood what was the nature of this guidance.
We were taken to various passages which it was suggested to betray that misunderstanding.
Yeah, so perhaps given we're on it, I could go to that.
Well, I don't want to take you out of your course, but I just wonder whether we're heading in that direction anyway.
Yes, it's entirely fair.
And maybe getting there is a good idea.
Yes. So, in terms of how the inspector treated it, if we look at the decision letter, page 213 of the main bundle extracted. Decision letter has a fairly clear structure. Paragraph 10 and following is development plan policy, and then paragraph 23 and following we go on to national policy and guidance. And paragraph 23, my friend focused on, emphasising the words now inconsistent, but paragraph 23, in fact, as I say, but indicates the inspector did not misunderstand the guidance. The last two lines in particular, the inspector said the interpretation of it, i.e. the framework, has been clarified. I emphasise the word clarified by more recent guidance contained in the PPG. So the inspector's, in terms, not treating the PPG as imposing some additional or stricter test. The inspector thinks it's clarification only, which is a similar concept to elucidation. So you have that that's the clearest example, I say, that the inspector didn't misunderstand the guidance or the nature of it. The next example I give is at paragraph 27.
Well, you've gone past paragraph 24. It's one of Lord Banner's paragraphs in his argument. Defined is the word he emphasised.
Yes, the inspector does more than once indicate that, in his view, the PPG is, to some extent at least, defining.
But is paragraph 24 a fair or not a fair summary of what the paragraph in the PPG is actually doing. Does it describe what it's doing accurately or not?
In my submission, paragraph 4 read fairly does fairly describe 728 on the basis that it does provide a definition. But it doesn't provide the sort of restrictive, prescriptive type of definition that my learned friend says would be illegitimate. It fairly faithfully records the actual words of 728. It doesn't record all of them, given the length of it, but...
Well, it's an exact quotation, isn't it, of the first paragraph?
Yes, exactly.
He doesn't put quote marks around it, but if you trace the words through, they're the same words.
Yes. So I say that he can't be faulted for doing that.
No, but maybe the point ultimately is he gets the words right, but he misunderstands their effect because he uses the word defined. And you say that doesn't matter because in the ordinary use of English, that's what's going on here.
Yes.
Is that what you say?
I do say that. I say, given PPG 728 says what is a reasonably available site and then explains it in ordinary English, that is providing a definition, not an exhaustive or prescriptive one, but a definition.
Well, a definition can be inclusive, can't it? You can say that an expression means X, Y, Z or includes X, Y, Z, and you're still in ordinary English defining it.
Yes. And it's an inclusive definition in this case. It includes potentially a series of sites, for instance, without necessarily excluding everything else.
We've reached 1 o'clock, and I suspect that there isn't going to be a convenient break anytime soon. You're going through the decision letter now, I think.
Yes.
With no pressure at all implied in the question. The question is, how long do you think you're going to take this afternoon?
Not more than 20 or 30 minutes.
Oh, I see. Then, Lord Banner, I hope you're not under undue time pressure.
No, and in reply, I won't repeat points I've already made, so I think I'll be 5 to 10 minutes max.
Good. All right. Well, we'll come back. Well, it's just a shade after 1 o'clock, so we'll come back at 2:05, please. Thank you very much.
Press.